order at page 35, para 10, the learned trial court is requested to proceed with the trial and to make an endeavor to dispose of the case as early as practicable without being influenced by any of the observation made herein above, as the same has been made only to dispose of the present application. So, but unfortunately, for some reason or the other, my lord, the trial is not going on because the new incumbent is yet to join in it, my lord. So the proceeding has been stalled in one way or the other way, my lord. Now, my lord, coming to the evidence.
Yes.
My lord, now coming to the merit of the case, your lordship, when the witnesses PW1, the headmaster was examined, my lord, the date of birth was recorded, my lord, and it was previously written as 16. Thereafter, it was altered and made into 6. So if we go by that calculation, my lord, there will be a huge age gap of 10 years, my lord. And the scan copy must have come, your lordship. So if your lordship will see the evidence of PW1, the headmaster who has thrown light on the age of the victim, my lord, at page 2 of his evidence, my lord, it is clearly written, he has deposed, my lord. In column of age in material exhibit 1, the age of the victim is overridden. It appears that material exhibit 1 by 1, the age was firstly written as 16, but later on it was written as 6. So that way, a huge age gap of 10
Evidence
years.
of PW?
PW1, inner page 2.
Yes.
From the bottom, say 8th line, my lord. In the column of age, material exhibit 1 by 1. The age of the victim is overridden. It appears that material exhibit 1 is the age firstly. Then this witnesses, the informant has also deposed, my lord, wherein the informant has been set to file this FIR by another person, my lord, who happens to be a witness in the other case. So coming to PW2, my lord, who is one Soyan Chakraborty, he is the brother-in-law of the accused. This, according to the witness version, the informant who has turned hostile in this case, my lord, that is PW3, clearly says that Vicky, that is PW2, Soyan Chakraborty, took her and the victim to PS and asked the informant to put her signature on a paper.
But Mr. Kamar,
Yes, my lord.
should we go to the extent of appreciating the evidence?
No, not nothing to appreciate it. What's appearing at the first glance, your lordship will have a look on that. So at the first glance itself, the case itself is not standing on its leg. So what will be the use for retaining me behind the bar? So your lordship has called for the scan copy, definitely to peruse it. Otherwise, we would have not called for it. So my respectful submission, when on merit now I have to submit, my lord. Otherwise, on what material will anybody submit after evidence is recorded? There is a trend of this honorable court that whenever the judges feel, they let the victim and the important witness go, then we'll see and we'll consider your bill. This is the trend going on, and accordingly, I'm making a submission on that front, my lord. That here, now, since there is no default bail case or wrongly arrested grounds, I can take it. So it's only the merit of the case that will determine my fate, my lord. So right now, what appears on the record, my lord? Record says, my lord, that PW3, who's the informant in this case, was declared hostile, my lord. Why? Because she was forced by PW3, 2, Sayan Chakraborty, who is a witness wherein I am an accused in another case of his cousin sister. So I read, my lord, PW3. I know the accused. Earlier, I walked in the house of the accused. The victim is my sister. I am the informant of this case. One day, Vicky came to our home and took my victim's sister and me in the police station. Accordingly, we went to the police station. Vicky gave me one paper and asked me to put my signature. This Vicky is PW2 Sayan Chakraborty. And asked me to put my signature. As I do not know how to write, I put the thumb impression in the paper. Then we return home. After the institution of the case, police sent my victim sister for medical examination. I accompanied my sister to hospital. I was not present when the doctor continued my victim sister. At this stage, learned special PP has sought permission of the court to declare the witness hostile. Considering the facts, the prayer is allowed. So crossed by the learned PP, it is not a fact that I have deposed falsely that Vicky took me and my sister to police station and asked me to put my signature in the paper. It is not a fact that I lost this case alleging the accused Wajid Hussain committed rape on my sister. It is not a fact that today I have deposed falsely before the court as dictated by the person related to the accused. On the date of lodging the azar, the victim told me the Wajid gave her 1200. I do not know why the accused gave that amount on that day. She was a maid servant actually working in her house. A victim was not working in the house of the accused. She worked in a factory at Nakhari at that time. And cross-examination by the accused. Vicky is the nickname of Shayan Chakraborty. My present age is 25 years. That 10 years if we add it. The victim is 2 years younger to me. The victim was in love affair with a boy and she got married to him about 2 years. I do not know the name of the person to whom the victim got married, but we call him Pitika. He expired about 1 month back. 2 women police and 1 male police along with Vicky came to our house. When police came to our home, the victim was on duty at Nakari factory. Police brought the victim for factory and we came to the police station thereafter. It was about 6 to 7 p.m. I never asked the victim whether the accused committed any offense or not. I do not know what was asked to the victim at the PS. The victim was kept in the police station and we returned home at 10 p.m. Vicky got the hazard strike. I did not state before police that the accused gave the victim rupees 1200. The victim also did not tell me that the accused gave her 1200. So this is the victim is at PW4. She was also declared hostile. Shall I read my?
No, not necessary to read
Well,
out
she has categorically stated that thereafter Sayan left me at my house. Police recorded my statement. I had sent to state that what Ajit has committed rape on me. One line, my love. The case was lodged falsely. I stated that I was asked by Sayan to state that Wajid committed rape on me. Sayan came to my house and told me the above fact. Then I gave false statement that the accused committed rape on me. So in a false case, my lord, when the victim herself is saying her age shown has to be. Fine. Bye.
None appears for the appellant on call. It appears that on 2 previous occasions also, no, on 3 previous occasion also, that is on 16/3/2026, 8/1/2026, and 11/9/2024, the appellant remained unrepresented. In that view of the matter, this court find no ground to adjourn the case to another date, and accordingly the same instance dismissed for non-prosecution.
Item 7.
Yes, pardon?
With the entered appearance by finding ballot number microphone for the respondent.
None appears for the appellant on call. However, Mr. Your name?
Yes, sir.
Yes, sir.
Yes.
Or learned counsel for the all the respondents?
Yes.
All the respondents present. You have file color number?
Yes.
Present. Later on, Mr. Your name, please.
Yes, I mean on behalf of B Sena.
Yes, I mean, learned counsel for the respondent, no, petition, no, appellant, remain present. Appearing on behalf of Mr. B. Ahmed.
B Sena.
Matter when listed for hearing, my lord.
Since service in this matter has already been completed and the records. Trial court record received
Yes.
and the trial court record have been, trial court record and also the record of appellate court, first appellate court has been received. This is at least the matter for hearing in usual course.
Okay.
May I plead your lordship kindly pass over the matter after some time? My senior counsel is other court.
Service to complete on that or evidence, hearing on the peaceful, let's see. Oh, admission. This completed.
May I please your lordship? Kindly pass over the matter for the day, your lordship. I am for the.
For the
petition-
day.
Yes, your lord. I am for the.
Sir, your
petitioner.
name, please.
A Chaudhary, your lordship.
Learned counsel
For the
for the
petitioner.
petitioner.
Yes, yes.
Press for adjournment of the matter for the day. Pair allowed. Matter extends adjourned for the day.
May it please, your lordship.
Lordship, if we have already done with the objection, just need to finally, we are getting the signatures from the respondent, your lordship. Date may be fixed, short date may be fixed as per the convenience of the next week.
Okay. Heard Mr. B. Kosik, learned counsel for the petitioner, and Mr.
A. Mishra on behalf of Mr. Estas.
Mr. Learned counsel for appearing for Mr. S. Das learned counsel for the respondent. The learned counsel for the respondent submits that his objection petition is ready and he may be granted 1 week time. Where allowed, this is at least the matter after a week.
Can it be on Friday, my lord, next Friday, 8?
Friday. 8 May.
8 or 13th.
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 Okay. Interim order passed earlier shall continue.
Grateful, my lord.
Thank you.
But office note reveals that, my lord, the service upon respondent number 2 is yet to be completed. Not yet complete, my lord.
You have not taken a step.
I have we have taken steps, my lord.
When?
But it'll be there in the office now. If required, we'll take fresh steps, my lord. We have already taken. Probably it's there in the office now.
You tell me the date.
At present, I don't have acknowledgement. I will write the code.
Heard
We
Mr.
have already taken the steps, madam. Otherwise, Roy, madam.
Learned counsel for the petitioner. And Mr.
And Karina on behalf of AILA.
And Colita, learned counsel appearing on behalf of Mr. AILA, learned counsel for the respondent number 1. Office note dated 28/4/2026 indicates that step upon respondent number 2 has not been taken by the learned counsel for the petitioner. Accordingly, it is provided that stake upon the respondent number be taken by speed post and also by usual process within 2 working days from today. List the matter after 4 weeks.
There is an interim order that means.
Interim order shall continue.
My lord, other three matters are similar, my lord. 12, 13 and 14.
12, 13 and 14.
Yes, my lord.
Okay. Parties are same there?
Parties are same, my lord. Similar order, same date, but cases are different.
Okay.
May I pray for short date, Lordship?
My lord,
Short date cannot be because
We'll take-
this
have to
has
take
to be
place.
served.
Dealing the matter, Lordship. As the dealing the matter, Lordship.
Okay, next date we will see.
I will.
Second, 15.
May I please, Your Lordship? Lordship, I list my item number 9, and appearing for a respondent in question.
Hmm.
Item number 9.
We are taking item number 15 now.
Lordship, I apologize, I just list my item.
Furniture particulars to court master. Yes,
Worship, in this petition, my lord, I prayed transfer of title suite number 174/2025, my lord, pending before the additional district judge Gauhati, my lord, and to the court of district judge Hailakandi, my lord. So my contention is that, my lord, in Hailakandi, another case is also pending, my lord, and respondent.
whether the other side have filed objection here.
Yes,
You
my
have
lord.
filed. So both the parties are ready to argue the matter.
Yes, my lord.
Suit is pending before the court of
Pending
additional
before
district
the
judge
Gauhati, my lord.
Gauhati,
Gauhati, my lord.
and it has to be transferred to
Hailakandi, my lord.
Hailakandi.
Yes, ma'am. And in Hailakandi, my
Who
lord,
is the petitioner?
petitioner is the wife of the respondent, my lord.
Why?
Wife, my lord. And respondent, my lord, already appeared in another case in Hailakandi, my lord. And he submitted his written statement also, my lord, in DB case number.
What is the number of that case?
DB case number 28/2024, my lord, annexer, page 16, my lord.
Okay. Yes.
So, my lord, I prayed, my lord, in Hailakandi, another case is already pending, my lord, and respondent also filed his written statement. He is appearing, my lord. So, title suit may also transfer to Hailakandi, my lord. And it is for the petitioner, my lord, too difficult to appear before the Gauhati, my lord. It is 450 kilometer, about 450 kilometer distance, my lord.
400?
And 450 kilometers, my lord.
Hmm. Any other ground?
No, my lord, I have.
Pending.
Yes,
Pending.
yes, madam.
We
Any objection?
should we have already filed our affidavit, let them reply.
No, what is the ground for objection?
Or
Pardon?
can we adjourn the matter for today?
Why?
Lordship, I am not doing the hearing part. My senior will be doing,
Who is your senior?
you does. I'm actually appearing on behalf of him.
No, I have inquired from you. Are you ready to argue the matter? You have answered it affirmatively that you are ready to argue the matter.
And no, actually, I heard.
As agreed by learned advocates of both the parties, recessal is the matter on 15th of May.
Most of
Okay.
no question.
May I please, your lordship? Lordship, I number 433 was filed, your lordship, for changing the address of respondent number 4, 5, and 6. And we have taken steps on 4, 5, and 5, 6, and 7,
Mm.
Your Honor. Lordship, as per office note dated 28/4/2026,
Mm,
in respect to respondent 7,
mm,
the service report has not yet been received,
mm.
lordship. And in respect to respondent number 4, 5, and 6, no such person were found at that address, lordship. So lordship, we may await for respondent number 7, so that in case the address is not found or service report does not come, then we can take subsidiary mode of service in respect to respondent number 4, 5, and 6 together with respondent number 7, lordship. At present, we may await for.
You are for respondent number
1, 2, 3, 8, 9, 10.
1, 2, 3, 8, 9, 10. 1, 2, 3, 8, 9, 10. Mr.
Lordship W. Hawk.
W. Hawk,
On
Learned
behalf of
Counsel
Mr.
for
A.
the
Sattar.
Learned Counsel, appearing for
Mr. A. Sattar.
Mr. A. Sattar, Learned Conducting Counsel for the. This is IA
I 443
applicant
for changing the address of 4, 5, and 6.
and Mr. Sharma, C. Sharma, Learned Counsel for the respondent number. So office note dated 28/4/2026 indicates that notice issued to the respondent number 4, 5, and 6 returned with a report. No such person at address. And state office note also indicates that neither ID card nor unserved notice issued to the respondent number 7 received till date. Is the matter after 2 weeks awaiting service report upon respondent number 7. Learned Counsel for the applicant submits that after receiving the report in respect of respondent number 7, step upon the respondent number 4, 5, 6 will be taken. Accordingly, it is provided that recessal leaves the matter after 2 weeks.
Obliged, lordship.
Lordship, service report is awaited for respondent number 4. And as for 1, 2, 3, Lordship, the report has come as insufficient address.
Hmm.
But it is a matter of fact, Lordship, the address is sufficient. Previously in the title appeal and the title suit, the same address was used. So we may be allowed to take the step in the matter for respondent number 1, 2, 3
Heard, Mr.
and Alif.
learned counsel for the applicant. Office note dated 28/4/2026 indicates that notice issued to the respondent number 1, 2, and 3 returned with a report insufficient address RTS. And said office note also indicates that neither ID card nor unserved notice issued in respect of respondent number 4 returned till date. The learned counsel for the applicant submits that he may be allowed to take fresh receipt upon respondent number 1, 2, and 3. They are allowed. Step be taken by speed post and also by usual process within a week from today. List after 4 weeks. Till then, await service report in respect of respondent number 4.
For hearing about the 41, item 35.
Milord, Milord, today I frame Milord two new substantial question of law, Milord. The Lordship, two new substantial question of law. The Lordship give permission, I like to argue on these two question of law, Milord.
No, yesterday we have adjourned the matter for today.
Yes.
What was the ground?
Milord, new ground, Milord, here. And two new grounds I have framed, Milord, for sub question of law involved, Milord. I have verified the records and also the trial court's finding, Milord. Two findings, two question of law I found, Milord. Accordingly, I framed two questions. If the Lordship give permission, I like to argue on these 2 points only today, Milord.
Mr. Decca, you see the requirement of
My
section
lord,
11,
since Milord, I have
section 100.
yesterday the
Subsection
two
3.
question of law I argued, Milord, that deputy Milord, these two most vitally, Milord, this question is important, Milord. Rest, I'm leaving the to rest yesterday's two question of law,
And
Milord.
you
This-
say,
Yes, Milord.
as per decision of Supreme Court and also as per subsection 3 to section 100, you have to incorporate the substantial question of law in the memo of appeal.
Lordship.
Then you have to bring on record this suggested substantial question of law
Then I will, Milord.
by
I'll do
filing
that.
in affidavit.
Yes, Milord. Then I'll do that, Milord. I'll, Milord. With appeal, Milord, I will, that substantial question law, I will. And Milord, before 15th of May, Milord, kindly be fixed, Milord.
Before
15th of May is the 15th of May, the execution report. Milord, some earlier date may be fixed. In the meantime, we will file this.
Okay. Heard, Mr. Decca, learned counsel for the petitioner,
Witness.
and Mr. Halloy for the respondent number 1.
Passport officer appointment আছে মোৰ।
Mr. Decca submits that he has he has suggested two more substantial question of law,
Tuesday কিমান তাৰিখ?
and he will bring on record say two substantial question of law by filing an affidavit.
On 5th of May, Milord. On
We are allowed.
Tuesday.
Rest is the matter.
On Tuesday, Milord, kindly, Milord. 5th of May, Milord, kindly.
On 6th.
6. 6. Left develop.
Item 36.
My lord, I have filed the affidavit, my lord. That is at like A, my lord.
Caveator would be hard carry distance resource.
But affidavit is at flag A, and my lord, The order dated 18/12/2013 is at page 143, my lord.
Page
143. The third paragraph, my lord.
Hmm.
May I read?
Hmm.
It appears from the report that on the basis of petition, this court by order dated 19/6/2013 rejected the prayer of the plaintiff side for production of the document as well as calling the officials of Tinsukia Municipal Board as witness, and against the said order, the plaintiff side went to the Honorable Guwahati High Court and the prayer of the plaintiff was allowed by the Honorable Guwahati High Court by order dated 8/11/2013 passed in CRP number 247/13 to the extent to issue summons to the official witness of Tinsukia Municipal Board without any direction or production of documents, as there was no prayer in that regard. It further appears that on receipt of the order passed by the Honorable Guwahati High Court, this court extend the opportunity to the plaintiff side for examination of officials of Tinsukia Municipal Board without any direction or production of any document, and the same is within the knowledge of the plaintiff as well as the learned advocate of the for the plaintiff. It also appears that where the production of documents through the official of Tinsukia Municipal Board was not allowed by the Honorable Guwahati High Court, and knowing fully well the fact the plaintiff side now turned up with a prayer for acceptance of the documents, which is indeed a document executed in between the plaintiff and the Tinsukia Municipal Board. Then, my lord, they have filed one another petition that were rejected. So the Honorable learned trial court also, my lord, in view of the order passed by this Honorable Court, has, my lord, decided to not to accept any document from the witness produced by the municipal board, my lord. And, my lord, against that order, they have filed one revision petition before this Honorable Court, but that they have withdrawn, my lord, later on, my lord.
No, you see, in the said order, this court has not prohibited production of any document by the witness.
My lord.
When he has been summoned to depose before the court, if he produce any document, can the court refuse it?
My lord, my submission is that, my lord, he is a official witness, my lord. PW3 is a official witness. He is a witness from the Tinsukia Municipal Board, my lord.
Hmm.
So he doesn't say anything out of the record, my lord.
Hmm.
And, my lord, the document, my lord, there is no prayer to produce any document, and, my lord, that's why this Honorable Court said that you summon the witness, but there cannot be any direction to produce the document.
Yes.
So that's why the court.
No,
is
that's
saying-
all right. There is no direction. But if on his own accord, if he produce any document or if he bring any document, then can the court prevent it?
My lord, my submission in that regard, my lord, is that if there is no direction to produce any document, being the
No, no,
official
no.
witness, my lord, he will.
That
He cannot be allowed to produce any document, my lord.
no. Then on what basis he will depose before the court? Because he is official witness.
My lord, he will simply say that the documents what is present in the
No,
court,
no.
my lord, that are the exhibited, my lord. That will be whether,
That kind of injunction cannot be granted by the court. And that may not also be the intention of this court.
because, my lord, this Honorable Court specifically says that, my lord, there cannot be any direction to produce the documents.
Now, is it your case that thereafter the trial court has directed to produce the record? What is the document?
My lord, the summon I do not have, my lord, the copy of the summon issued to the, my lord, municipal witness, my lord. But, my lord, the order sheet, it is not clear that
Hmm.
whether any direction is.
Then?
there.
So there's a exhibit number 5 to 12 were produced by that witness.
That witness, PW3, my lord.
No, Your Honor, only 6 and 7.
No.
Only 6 and 7, I filed, yesterday I filed a affidavit of, township and cross. It's not on the record. I want the copy. I filed an affidavit, but in the PW1, he said that only, I think 6 and 7, he has brought 2 documents. Exhibit 6 and 7. Other documents are of the printed.
No.
1 to 4, 5 with the summon, and 8, 9 are of the printed.
When did you file the affidavit?
Yesterday. After, I have 1 copy.
Okay, we'll call it. We'll take it up day after tomorrow.
On Monday, my lord.
Saturday.
Saturday.
Can it be on Monday, my lord? Saturday I have some difficulty.
Okay. Mr. Gupta, learned counsel for the appellant, and Mr. Gogoi for the respondent. Mr. Gogoi submits that he has filed an affidavit yesterday, but the same has not been placed on record. Justice shall list the matter on Monday by taking the affidavit filed by the respondent on the record.
All right.
What like? Item number 2.
May it please your lordship. This regular second appeal by defendant number 1 and 2, lordship. Plaintiff filed a suit for right title, interest and recovery of possession, lordship. That was dismissed. Then they preferred one title appeal, which was remanded back by framing 2 additional issues. Thereafter, their suit was dismissed. After remand, order is annexure 4, page 45. Assam Municipal Case. I have formulated 2 substantial question of law as on the one is non-service of notice under section 326 of the Assam Municipal Act, which is mandatory. Learned trial court held that due to non-service of notice, their suit is not maintainable. And one is their suit is barred by law of limitation. That is 4th substantial question of law. Learned trial court held that their suit is barred by limitation, lordship. But all other issues were in favor of the plaintiffs, lordship. But when the suit was dismissed, lordship, as not maintainable, barred by limitation, so plaintiff filed the title appeal, that is annexure 5, page 69. And first appellate court reversed those 2 issues in favor of the plaintiffs, lordship. Page 92, your lordship will find the findings of how the suit is not maintainable. Page 91.
Okay.
Paragraph 20.
What is the requirement of section 326 of the Assam Municipal Act?
Before instituting any suit, notice has to be served to the Assam Municipal Board. That mandatory.
Whether Assam Municipal Board Was the party in the title suit?
Yes, Lordship. After remand, they were made party.
Where is the remand order?
Remand order, that is annexure 3, page 36. Relevant portion is, Lordship, that is page 43. Having considered the matter in its entirety, last paragraph, Lordship.
Hmm.
I am having considered the matter in its entirety.
Paragraph number?
Paragraph, Lordship, it's page 43, last portion. It started paragraph 5, Lordship, page 41. Then it continued to page 43, last 4-5 lines, Lordship. Having considered the matter in its entirety, I am of the view that the following issues are required to be framed for decision of the suit in addition of existing issues. Whether the suit is bad for non-joinder of necessary parties, whether the suit is properly valued and proper court fee has been paid. This judgment was delivered on 9th day of November 2013, page 36. Thereafter, municipal board was made party. So learned trial court held while deciding whether the suit is maintainable or not. Issue number 2, page 57, your lordship will find at the bottom there is written as issue number 2, but discussions in page 58.
Page?
Page 57, last line, lordship, issue number 2. Only that part is written near the signature of Munsif. lordship.
Hmm.
The discussions in page 58. Is the suit maintainable in the present form and manner? The learned counsel for the plaintiff in the written argument submitted that this is a suit for declaration of right, title and interest over the land mentioned in the schedule of the plaint and for getting khas possession. It has been submitted that there is nothing in the written statement for which the instance suit can be termed as not maintainable. In fact, the present suit is very well maintainable in the present form and manner. On the other hand, learned counsel for the defendant have submitted that the suit is barred under section 326 of the Assam Municipal Act for want of mandatory notice as required for bringing suit as against the Municipal Board, Lakhipur. In view of provisions of section 326 of the Assam Municipal Act 1956, no action can be brought against Municipal Board or their officers until after clear 1 month notice of cause of action. The impleading of Lakhipur Municipal Board is clearly in violation of the provision of section 326 of the Assam Municipal Act 1956 and the suit is not maintainable and is liable to be dismissed. Findings, perusal of available materials. From the bottom second paragraph. Perusal of available materials on record reveals that the Lakhipur Municipal Board has been added as defendant by order dated 30/6/2014 and no notice under section 326 of Municipal Act was served on Lakhipur Municipal Board and the PW1 also admitted the same in his additional cross-examination. In view of the above provision and the fact that the plaintiffs have failed to serve the notice as required by the section 326 of the Assam Municipal Act, I am of the considered opinion that defendants have succeeded to show that the suit is not maintainable and this court also after perusal of relevant provision of law and the materials on record have found ground to hold that the suit is not maintainable in its present form and manner. So this issue was decided against the defendants. Now issue number 3 is the suit barred by law of limitation that was also decided against the plaintiffs. These two issues were reversed by the learned first appellate court. So against that lordship, I am before your lordship.
These two issue means issue number 2 and
2 and 3.
2 and 3.
Yes. First appellate court held that suit is not barred by limitation and suit is not defective for non-service of notice upon respondent that municipal board.
So what wrong with the finding of the appellate court?
Lordship, this is a mandatory requirement of serving notice to the board lordship. That was not done. So trial court was rightly held that non-service of notice, the suit is not maintainable.
No, the
And,
question is
suit is-
whether you have sought for any relief against the municipal board,
The plaintiffs sought for relief, lordship.
against the municipal board.
Yes, lordship. That is page 25. The prayer portion, their original plaint I am reading. Type copy I have given, but I am reading from the original. For a decree declaring the right, title and interest of the plaintiffs over the land described in the schedule below. For a decree that to restore the possession of the plaintiff over the whole land described in the schedule below by demolishing all sorts of constructions made by the principal defendants, number 1 and 2. For a decree declaring that the entry in the register, assessment register in respect of holding number so-and-so of ward number 2 of Lakhipur Town Committee is incorrect and malafide. So there is an allegation against the Lakhipur Town Committee. And in the pleading also, they have stated that the town committee malafidely recorded our name. We have purchased the land, thereafter our names were entered in the holding number. Then we have started in our construction in our possessed land. Against that, the plaintiff filed this suit. There is a clear allegation against the town committee, page 8 and 9. Page 8, last 4 lines. On inquiry, the plaintiffs could come to know that the Lakhipur Town Committee had accorded permission to the principal defendant number 1 and 2 for construction. Immediately, the plaintiffs lodged written complaints to the chairman, Lakhipur Town Committee, with copies to the district administration for cancelling the said permission for construction, reminding its earlier order dated so-and-so, but the Lakhipur Town Committee did not make any response till so-and-so, and the principal defendants went on with their construction work of the houses day and night. On so-and-so, it was informed to the plaintiffs by the vice chairman, Lakhipur Town Committee, by its letter number so-and-so, to the effect that holding number so-and-so of Ward 2 Lakhipur stands in the name of late Abdul Manaf, father of the principal defendant number 1 and 2 in the town committee. Thereafter, the last 4 lines of the same paragraph. Therefore, there are reasons to believe that the principal defendant number 1 and 2 have their long hands in the town committee too, and collusion with its officers or any other agency, it got manipulated the assessment register of the Lakhipur Town Committee. So allegations are there, prayer is there in favor of the Lakhipur Town Committee. So they are necessary parties. For that, they were impleaded in the year 2014. And lordship, the suit is barred by limitation. It was already held by learned trial court. That was also reversed by the learned first appellate court. May I read the issue number 3? Page 59 by the trial court.
Trial court all right, but
First appellate court.
yes.
Page 92, paragraph 22. Now coming to the decision of the learned trial court in issue number 3, which relates to the law of limitation, it appears that the learned trial court held that the suit is heavily barred by law of limitation and accordingly decided the said issue number 3 against the plaintiff's appellants. The relevant paragraph of the impugned judgment of the learned trial court in issue number 3 is reproduced below. The Lakshmipur Municipal Board has been added as defendant by the order dated 36/2014, as the presence of the board is required to enable the court to effectually and completely adjudicate upon and settle all the questions involved therein. The Lakshmipur Municipal Board has been added as party after 14 years of the institution of the suit. The plaintiffs have admitted in their plaint that the cause of action has been arisen in 1994 and 2000, and also admitted during argument that the prescribed period of limitation for declaration of right title and interest and for getting khas possession is 12 years. As such, the limitation period is already lapsed. Learned counsel for the appellant side has submitted during course of argument that the decision so arrived at by the learned trial court in issue number 3 regarding limitation etc. is erroneous because Lakshmipur Municipal Board had not been constituted prior to the filing of the suit and or accrual of the cause of action, and moreover the defendants failed to show by way of producing any documentary evidence that the suit land falls within the jurisdiction of Lakshmipur Municipal Board at the time of filing of the suit. In their suit, they have pleaded that Lakshmipur Town Committee granted permission in favor of the defendant. Now they are saying that Lordship, at the time of filing of the suit land falls in the town committee, we have not shown. It is not our duty to show that the Lakshmipur town suit land falls in the area of Lakshmipur Town Committee. They have already mentioned in their plaint. Upon close scrutiny of the materials on record, the judgment passed by then Civil Judge 2 Kasar Silchar and the impugned decree dated so-and-so passed by the learned lower court, it transpires that the Lakshmipur Municipal Board was added as party defendant by the order dated so-and-so of the learned lower court, as the presence of the board was required to enable the court to effectually and completely adjudicate upon and settle all the questions involved therein. Thus, it cannot be said that due to the arising of cause of action in 1994, 2000, and also for adding the Lakshmipur Municipal Board as party after 14 years of the institution of the suit, the limitation period has elapsed. The Lakshmipur Municipal Board has been added as per order of the court on 36/2014. Hence, the limitation would run from the date of adding the municipal board as party defendant. Thus, when the limitation period would run from 36/2014, that is from the date of adding the Lakshmipur Municipal Board, by no stretch of imagination, it can be said that the suit is barred by law of limitations. Therefore, in light of the foregoing discussions, this first appellate.
That's all right. In fact, when the Lakshmipur Municipal Board was constituted,
Lordship.
when?
2004.
2000?
When constituted, Lordship, that is not within our knowledge, but plain they have stated that we have taken permission from Lakshmipur Town Committee. That pleading is there. In 2000. Page 9, it was informed to the plaintiffs by the Vice Chairman Lakshmipur Town Committee by its letter number LTC number so-and-so dated 29/3/2000 to the effect that holding number so-and-so of Lakshmipur stands in the name of late Abdul Monab. And permission before that, the first two lines, Lakshmipur Town Committee with copies to the district administration for cancelling the said permission for construction, reminding its earlier order dated 97. So in the year 1997, there was the Lakshmipur Town Committee. Before that also there was Lakshmipur Town Committee. Paragraph 4, first 2-3 lines, that the principal defendant number 1 and 2, suppressing the fact of the said deed of rectification number so-and-so tried to obtain permission for construction of their house, showing only the deed number so-and-so of 94 to the Lakshmipur Town Committee in the year 1997. So as per their pleading, Lakshmipur Town Committee was there in the year 1997. And they have mentioned that cause of action arises in the year 1997 and 1994. These are the two issues to be looked into. There is a perversity by the first appellate court, Lordship, in deciding these two issues. So the suit of the plaintiff.
You see, Lakshmipur Municipal Board has been implemented as party
Yes.
as per direction of the court.
Yes.
So whether in that case, the requirement of section 326 will be applicable?
Yes, Lordship, though there was a direction to implement, but the mandatory requirement of the act has to be, Lordship, fulfilled by the plaintiff. This is the 326 says no action to be brought against the board or their officers until after 1 month's notice to cause of action. As first, we have raised a point non-gender of parties. After that, the additional issue was framed, and after that only the parties were implemented. No suit or other legal proceeding shall be brought against any board or any of its officers or the any person acting under its direction for anything done under this act or any rule or bylaw made thereunder until the expiration of 1 month next after notice in writing has been delivered or left at the office of such board, or also if the suit is intended to be brought against any officer of the said board or any person acting under its direction at the place of abode of the person against whom such suit or proceeding is threatened to be brought, stating the cause of suit or proceeding, the nature of the relief sought, the amount of compensation claimed, and the name and place of abode of the person who intends to bring the suit, and unless such notice be approved, the court shall find for the defendant. Every such action shall be commenced within 3 months next after the accrual of the cause of action and not afterwards. These are the requirements of act. Because of these mandatory requirements says that if notice was served, they may have considered the grievance of the plaintiff. Third, 3 says if the board or its officers or any person to whom any such notice is given shall before the suit is brought tender sufficient amends to the plaintiff, such plaintiff shall not recover. So this is the mandatory requirement of the act, Lordship, to bring any suit against the board. And they were directed to implement this party only because we have raised a objection that suit is bad for non-gender of necessary party.
So after the section 326, 2 case laws have been discussed. One is 1984 1 JLR 386 and the other is 84 1 JLR.
Lordship.
Oh, same.
Devendra Ujali and
Yes.
the same Devendra Ujali versus Borpeta Municipal Board.
One more decision is there, that is 1984 1 JLR NOC 31.
Yes, Lordship. Chairman Dhubri Municipal Board.
In the first case, it was held that the provision of section 326 is not applicable.
It has been held that the provision of section 326 is very much constructive and colorable exercise of powers do not come within the scope of section 326 of the Act.
Let us list the matter on Saturday, day after tomorrow. In the meantime, you come prepared with
These two decisions.
decisions.
Lordship, Saturday I have some problems, so tomorrow to bondho, no?
Because Saturday less number of cases are fixed.
Lordship,
So we can-
Saturday I will be out of Gauhati.
Fine. Part are Soduri Learned Senior Counsel assisted by Learned Counsel for the appellant. Part in part, list the matter on
Yes, sir. No.
on with me for further consideration.
Lordship, deeply apply.
Mr. Ahmed here, service completed.
The service completed. Last occasion also they are not appeared. No representation, so petition may be heard expertly.
So we'll fix the matter for admission then. Heard. Mr. J. Ahmed, learned counsel for the petitioner. Since service in this matter has been completed, in view of the office note dated 10/11/2025 and in view of the order dated 18/3/2026, this is the matter for admission. After 1 week,
Date
okay.
On 20.
Or can it be on Saturday?
next
Coming Saturday.
Next Saturday. Second May.
Not interested.
No, but it may fix.
Okay.
Second May.
Okay.
I chance for hearing.
Exam.
19 partner with.
My lord, before my lord, make submission, my lord. I just make a request, my lord. Yesterday, my lord, I have attended my funeral ceremony of my sister-in-law. And I have got, my lord, less time to prepare the case. Even then, my lord, I can start, my lord, if necessary, lordship may kindly accommodate me next week, any date, my lord.
After?
Next week, any date, after 4th. Because some decision, my lord, I could not go through. I could not go through the some decision. Because matter is, I have lost the case in both the courts, and issue is very tricky issue. My lord, whether there was any family
Next week
settlement.
may not be possible.
If, my lord, subject to convenience, my lord.
Heard Mr. Purkasa, learned counsel for the appellant, and Mr. Talukda for the respondent. On the pair being made by Mr. Purkasa, learned counsel for the appellant, the matter is then adjourned to be listed after 1 week then.
After 1 week. Yeah, lord, a pardon matter.
Correct.
20th. Yes. I'm extremely sorry, my lord. I'm very sorry, no? Sorry.
Actually, 20. Partner meter.
May I please, my lord?
Hmm.
My lord, on the last occasion, my lord, my friend has raised the objection with regard to maintainability of this revision petition, my lord.
Mhm.
My lord, what happened in this case, my lord, the suit was dismissed for not producing the evidence, my lord. Then, my lord, I have filed one petition under Order 9, Rule 9, my lord. That was dismissed on the ground of delay. My lord, I have checked, my lord, he is right, my lord, Order 43,
Hmm.
1 C, my lord. It says, my lord, appeal lies, my lord, Order 43, 1 C.
One C,
Yes, my lord.
order 9,
An
no,
order
rule 9 of order 9.
rejecting an application for an order to set aside the dismissal of a suit. So, my lord, appeal will lie under Order 43, 1 C, my lord. So I may be allowed to withdraw this revision with liberty to file the appeal, my lord.
Okay. Heard Mr.
Appeal will
Gupta,
be
learned.
Before the district judge.
Yes, my lord.
Appeal will now be lying before the district judge.
Yes, my lord.
Okay. Mr. Gupta, learned counsel for the petition, and Mr. Risas, learned counsel for the respondent. Mr. Gupta submits that he has a instruction to withdraw this petition. with a liberty to approach appropriate forum by filing appropriate petition. Where allowed. This the CRP number 93 of 2024 thus dispose of withdrawal. However, liberty will remain with the petitioner to approach appropriate forum by filing appropriate petition.
My lord, may I pray for one observation that, my lord, since the time period for filing the appeal has already expired, my lord. So some observation that, my lord,
No, Article 14,
yes, that is there, my lord, but
That is directly there, Your Lord.
that
not
is-
necessary.
Pursuing in a wrong forum.
Yeah.
That is there. It will be covered by that.
Yes.
obliged.
Obliged. Item 22.
Yeah, please, your lordship.
Mm.
This RSA has been preferred against the appellate order caused by civil judge number 2, reversing the judgment passed by the junior division number
Mhm.
1. In this, the suit was originally filed by the plaintiff and I was, appellant was the defendant. The suit was filed. The contentions of the said plaintiff was that one Sodesar, their pleadings is like that.
Order, my lord. I love that. I like to state one fact, my lord. Execution has been completed and a report to the effective court has been there. The decree has been.
Decree satisfied.
Your lordship, I have,
If your lordship wants to call for a records of the execution case, they could be better, my lord.
No, if he admits that decree is executed, then not necessary. Executed decree.
your lordship, on the basis of an unregistered sale deed, by the misleading the court, they have taken possession. They have not, their contention in the plea was on an unregistered sale deed, your honor. So earlier, your lordship, the Munsif, the civil junior division has dismissed their suit. And their claim of title is on the basis of an unregistered sale deed, and that view has been taken here by the learned body because under section 17 of the Registration Act, when the value of the land, immovable property is more than 100, your lordship, registration is the vital.
Mm.
They have not been able to prove.
It is, my lord, merit.
Let me
I can
finish.
also come.
Yes.
Now, the thing is that, my lord, whether the decree is satisfied.
Why?
I just want to show that document.
Yes,
He
it
can
is
carry on, my lord.
let me finish my argument.
Mm.
So, your lordship, at this regarding this order against the judgment, they have preferred an appeal. So I have come before the appellate court. Appellate court reversed without any giving reasons or decisions why, how a party on the unregistered document can seek a declaration of title, your lordship. So without waiting, they have misleading the court, executing court. They have taken possession. In the suit, they have sought for a declaration of right title and for recovery of possession, your lordship. Till the date of eviction, by misleading the court officials that they have got a title, the pending, the appeal is pending, they ought to have waited. But they know the misleading that by taking the court judicial machinery, they have taken possession. And if I succeed in this appeal, we can file for a restoration. That is a different issue, Your Honor. First of all, why I have to file this second appeal? Court has to see.
Section 47 application was also filed.
Yes.
Before that.
No, that is a different thing. First of all, court will decide whether the appeal, second appeal is maintainable or not, Your Lordship. Whether they have got title or not. So against that order, I have preferred. So how their contention in the plaint was that once Sodesar Das their contention in their pleadings, have executed one registered mortgage deed
Mm.
in favor of, with respect to a 10 lessor for a term of 3 years with a consideration of 10% if the amount is not paid. Thereafter, in the year 1974, in the month of April, after 7 months, their contention is that the said was suffering, so he had further executed the sale deed. What sale deed? That exhibit 1 is the said power said mortgage deed.
Let us go to the judgment of the trial.
Yes, trial court, your lordship. Trial court has specifically considered that when the your lordship, I will after filing of the your lordship written statement and the plain on pleadings, these as around 8 at page 22, your lordship, 8 issues were framed. Whether there is any cause of action for the suit, whether the suit is barred by limitation, whether the suit is bad for non-joinder of necessary parties, whether the plaintiff has right, title, and interest over the suit land, whether the plaintiff was in possession of the suit land and defendant have dispossessed the plaintiff from the suit land, whether the defendants are protected by the right of adverse possession. In the WS, we have stated that prior to 1974, the suit was under possession of the father-in-law of the defendant and the father of the defendant, earlier defendant after People Das had expired, the present defendant, appellant, were impleaded. And it was under possession of the Sibaram Das, one Sibaram Das, which we have stated in our written statement. And till the date of disposal, till the date of filing, we have been in possession by right of adverse possession. So there is no any deed we have pleaded in our written statement. There is no any deed of mortgage this to be executed by that Sodesar Da. So there is
Only one thing, my lord, before my lord comes, written statement filed, no evidence has been.
No, I am coming to that.
So at this
Your
point,
Honor, it is in the order sheet. Everything is in the order sheet. I am reading it
written
out.
statement can be taken.
I am reading it out. What the
Why?
order says.
Why not?
No evidence has been given. The presumption can be laid, my lord.
Yes.
The Supreme Court.
No, no.
Verbal-
Let me finish
statement
my
was not
judgment.
filed.
No, we have filed 4 evidence, neither that has been.
Your Honor, their suit has been dismissed. It is the burden of the plaintiff to prove his title. There are lots of decisions of the Supreme Court.
Yes, yes.
They cannot hamper that we defendants could not prove the case. That is not our case, Your Honor. It is their case.
Yes, yes.
They have to prove it.
I agree to that.
Whether they have right title and interest, court cannot give an order without having right title and interest. Position. They have sought for a recovery of position. Your Honor, I am coming to that. They want to say that we don't have any evidence. It is specifically written in the judgment, Your Lordship. On peremptory hearing, plaintiff side have examined evidence of 4 numbers of PWs and they were not cross-examined. And defendants have failed to adduce evidence. That is a admitted fact. It is in the record. It is in the judgment. There, the decision number 3, main issues, Your Honor, what has been decided in the trial court, junior division court, issue number 4 and 5. According to the plaintiff, one Sodesar mortgaged on 22,470 about 10 lessons of land along with 4 rooms to him for 3 years for consideration of rupees 2,500 and delivered possession of the same. Their contention is like that. But in the said mortgage, there is no delivery of possession has been stated. There are 3 exhibits. Exhibit 1 is the registered, according to them, mortgage deed. Exhibit 2 is one receipt. And exhibit 3, one unregistered sale deed. It is in the trial court evidence, Your Honor. They are documents. On these documents, they are hampering. Your Honor, what? And it has been said thereafter, being in urgent need of money, sold the same to the plaintiff for a consideration of 70,000 and executed sale deed in favor of plaintiff on 5/11/74. Earlier, one mortgage deed was executed, and after 7 months,
another unregistered sale deed was executed. And presented that their contention is presented the same of registration in office. And according to the plaintiff, an area of 10 lesser was small. The sub-register declined to register as and kept the same pending. Your Honor, it has been, there is some clerical mistake in the said judgment. Exhibit 1 is the copy of the sale deed, but Exhibit 1 is the mortgage deed. Exhibit 3 is the copy of the sale deed executed by Soder in favor of the plaintiff. And that Exhibit 1, it ought to have been Exhibit 3. Exhibit 2 is the receipt. Their contention is that as the land was of small nature, the sub-register did not register it. So receipt they have given. Exhibit 1 received as sub-register. As per Section 17, Your Honor, of the Registration Act 1908, if the value of immovable property such as the land is of 100 rupees, and according to them, they have mentioned, they have stated in their Exhibit 1 that the property has been mortgaged for around 2,500. So in that case, and they have already been stated that they have sold around 70,000. So it is more than 100. So it is a mandatory that any transfer of property, if it is executed for immovable property, that has to be 100 and more. That it's a compulsory registration is a must under Section 17.
So how the trial court has dealt with that issue?
Yes, Your Honor, I am correct. As per the second section, if the value of the immobile is such as landlord is 100 rupees, such document must be compulsory registered. But it appears from Exhibit 1 that the consideration amount of the landed property is 25,000, but it should be 2,500. So the sale deed has to be compulsorily registered. Whatever area of land might be without registration, the sale deed cannot be said to have been executed, and it is not a valid document in the eye of law. That finding has been given by the learned trial court. The plaintiff has also failed to examine the official. If their contention is correct that it is a 10 lesser, that it cannot be registered, they ought to have called the officials of the service to prove their sale deed. Yes, because it is a small plot of land, so it cannot be registered. They have not submitted any adduced evidence to that effect. So the sale deed is not proof. You know, sale deed is not proof. In the absence of the valid sale deed, the plaintiff has failed to prove his right title in interest over the suit land and as well as possession, Your Honor. Further, according to the plaintiff, one Potoldas who was a tenant in the house standing over the suit land informed him that on 9/2/88 at around 7:30 p.m. the defendant along with his brother forcibly entered into the room, occupied him and threw out his belongings. But the plaintiff has failed to examine the said Potoldas. Your Honor, that Potoldas itself is a tenant of the defendant. There are the houses of the defendant. Since the prior to 1974, the defendant has been under possession of the said land. And that tenant, if he says that it is their tenant, the plaintiff ought to have adduced him to show that they were in possession, that defendant has illegally dispossessed. Their suit has been filed for declaration and recovery. That it is a cropped up case made by the plaintiff, Your Honor. So accordingly, there is no, although we have not adduced evidence, that is a separate thing. We have sought for we have stated that we have been possessing by adverse possession since the year 1974. That will come, Your Honor. Since the plaintiff has failed to prove the right title and interest and possession and his alleged disposition from the suit, so there is no cause of action, and accordingly the suit has been dismissed. So my submission is that, Your Lordship, then against the order, there is an order passed by the appellate court. What order has been passed, Your Honor? Your Lordship, at page 9 of the my memo annex document of the judgment, at page 9, Your Lordship, internal page 4. Against the appellate order, I have preferred this second appeal.
Page number?
Page number 9, internal page 4.
Yes.
In the last portion, Your Lordship, upon perusal of the certified copy of the judgment under sentence passed by the learned trial court as well as evidence adduced by the plaintiff side during trial of original and the documents submitted by the plaintiff during hearing. Your Honor, it is found that by Exhibit 1, that is the mortgage deed was executed and it was registered properly. It is no doubt the mortgage deed. Your Lordship, by and mortgage deed, transfer cannot be given here, cannot be executed. Exhibit 2 is found to be the receipt given by the sub-registrar. Dated 5/11/7. Exhibit 3 is found to be an agreement dated 4/12 between Sodeswar Das and Bhavananda Das, which is found to be a Katsa deed of selling of land of 10 lesser by Sodeswar Das. But upon perusal of Exhibit 1, which is proved in original, that is a mortgage deed Exhibit 1. By learned predecessor on 23 to 12, found to be a mortgage deed in between Sodeswar Das and Bhavananda Das, dated 22/4/74, and it is not a sale deed prepared by Sodeswar Das to the plaintiff presented before the sub-registrar on 5/11/74. As per Exhibit 2, received bearing serial number 10 so and so, dated 5/11, and the said deed of whatever nature left to be proved here in original title suit by the plaintiff, and as such acceptance of Exhibit 1 to be an unregistered deed is based upon segment image. Your Honor, learned trial court, appellate court has come to a different finding. Whether Exhibit 1 is a registered deed or not, that finding has been, first of all, Your Honor, it has to be come to a decision whether that sale deed is properly executed, whether it is valid or not, that has to be decided, Your Honor. So any sale deed, learned appellate court also discussed, Your Honor, any sale deed allegedly executed by plaintiff on 5/11 is left to be proved. Appellate court himself stated that it has left to be proved in any manner in the proceeding of the original suit, and finding of the learned trial court accepting Exhibit 1 a mortgage deed as an unregistered deed presented by the before registering authority with a registration. Exhibit 2 found not tenable and the issue decided on the basis of the same found to be having wrong finding, upon which the decision arrived by the court could not correct and hence not tenable. What kind of judgment it has been given, Your Lordship? First of all, learned trial court has specifically stated that under Section 17, when the value of an immovable property is more than 100, it is a compulsory registration. So what kind of judgment it has been passed, Your Lordship? It has passed that whether it is not a case and it is not an issue that whether Exhibit 1 is a registered or unregistered, but it is a value. They have sought for a declaration, Your Lordship, on the basis of a title and recovery of possession. And learned trial court has rightly passed, seeing that the value is more than 100. So any transaction, any sale deed executed, it has to be registered. So in the result, finding the appeal having merit, it is allowed on contest the judgment decree passed by the undersigned is set aside. How recently the original suit bearing number is decreed. How court can give a decree to that effect? My humble submission is that how the first appellate court decreed the suit in absence of a valid sale deed on the basis of a mortgage deed. Your Honor, there is a mortgage. This is a simple mortgage. There is a mortgage also under conditional sale. Whether that condition is stated in the mortgage deed under Section, Your Honor, 58C. So whether that mortgage deed can be converted into a sale deed. Conditional sale. There is a condition for sale also that it can be converted. There is no such condition that that mortgage deed can be converted into a sale deed under Section 58C. If there is a condition, that is a different issue, Your Honor. My humble submission, how the plaintiff can gain ownership till title over the slab without proving the sale deed? Exhibit 3. And my last submission is that, Your Lordship, not the least, how court can decree the suit without any discussion, decision, as the same being an unregistered on the main issues, Your Honor, without valid discussion has to be given under 41 Rule 30, Your Honor. I have some decisions which it has been reflected. If your honorable court, these two decisions I want to rely. 2014 two Supreme Court cases, 269. It is a suit for declaration, your lordship. 2114 two Supreme Court, 269. Your lordship, their suit, kindly go to the plaintiff, your honor, they have what they have sought. At page 31, your lordship.
Page?
Page 31 of their plaint has to be seen. Your
Yes.
Page 31 of the memo of appeal and
Yes.
next document. They have sought for a declaration of his right title at in the prayer portion, your lordship. They have himself stated that we have dispossessed. So they have sought for it. In the prayer one, declaration of his right title over the suit length and lesser. Number two, recovery and delivery of possession by evicting the defendant. Your lordship, till the date of illegal disposition, I will say illegal disposition by misleading the executing court, the defendant were in possession since the year 1974. And they have, so that's why they have sought for a recovery of possession. For permanent injunction restraining, they have stated that we have constructed illegally, but that is a different thing. We are renovating our houses which has been built by our predecessors, your lordship. For
So,
permanent injunction and also value for demolition. That prayer they have sought for in the plain.
Defendants were in possession since
Prior to 1974. There was no occasion on the part of the successor to execute any mortgage deed or other sale deed without having possession over the said 10 lessers by successor as well as the plaintiff. These are all paper transactions they were given here, where they have shown in the state trial court. So their prayer is there in the year. Your Honor, what this judgment says, Your Honor, they have sought for a title. Suit for declaration of title and possession according to the state.
You are referring to which one?
Your
2014
Honor,
or 17?
2014 two Supreme Court cases.
Okay.
269. It has
Paragraph
been
number.
very nicely explained.
Paragraph number.
Your Honor, paragraph number 15 to 19. 15 to 19, Your Lordship.
Yes.
It is a tried law that in a suit for declaration of title, the burden always lies on the plaintiff to make out and establish a clear case for granting such a declaration, and the weakness, if any, of the case set up by the defendant would not be a ground to grant relief to the plaintiff. I have already stated they are hampering that we don't have any evidence. Our weakness doesn't matter in a suit for declaration. They have to first, burden always lies upon the plaintiff to prove their own case. They cannot hammer upon us that we don't have an evidence or we have not given proper evidence. So High Court, we notice, has taken the view that once the evidence is laid in by both the parties, the question of burden of proof pales into insignificance, and the evidence laid in by both the parties is required to be appreciated by the court in order to record its findings in respect of each of the issues that may ultimately determine the fate of the suit. The High Court has also proceeded on the basis that initial burden would always be upon the plaintiff to establish its case. But if the evidence laid in by the defendant in support of the case probabilized the case set up by the plaintiff, such evidence cannot be ignored and kept out of consideration. At the outset, let us examine the legal position with regard to whom the burden of proof lies in a suit for declaration of right and possession. The court in Moran Vasilios Catholics versus Thukalan Paulo Arvide observed that in a suit for declaration, if the plaintiffs are to succeed, they must do so on the strength of their own title. So at this moment, they have not a registered sale deed, don't have a title, Your Honor. The onus to prove the title to the property is question was on the plaintiff respondent. In a suit for rejectment based on title, it was incumbent on the part of the Court of the Appeal first to record a finding on the claim of the title to the suit land made on behalf of the plaintiff. Learned Trial Court has already established that since the sale deed is not registered, so section 17 has been not complied with. So how it is an invalid document? The court is bound to inquire or investigate the question first before going into any other questions that may arise in a suit. Number 90, the legal position there is clear that the plaintiff in a suit for declaration of title would succeed only on the strength of his own title, and that can be done by adducing sufficient evidence to discharge the onus on it. Sufficient evidence, there should be sufficient on the part of the plaintiff. At this stage, in the suit, they have not given any documents, valid document to prove their title. Irrespective of the question whether the defendant have proved their case or not. Same here, similar to our case. So we are of the view that even if the title set up by the defendant is found against, in the absence of establishment of the plaintiff's own title, the plaintiff must be non-suited. So they don't have a case, Your Lordship. So there is another decision of the Supreme Court. What first appellate court has to do here before going to a judgment, before giving a clear judgment? It is paragraph 12 to 14, Your Lordship. 2017 two Supreme Court cases, 415. Powers and the duties of the first appellate court. Paragraph 12 to 14, Your Lordship. 2017 to 17 two Supreme Court cases, 415. Your Lordship, at para 12, Your Lordship, as per Order 41, Rule 31 CPC, the judgment of the first appellate court must explicitly set out the points for determination, record its reasons thereon, and to give its reasoning based on evidence. Your Honor, if Honorable Court has gone through the appellate judgment, whether there is decision, discussions, not a single discussion, only they have discussed whether mortgage deed was registered or not. They have, appellate court himself stated that it is a case for to prove by the plaintiff at the trial court. The sale deed is duly proved or not. Whether it is not the duty of the appellate court to discuss on this, that said sale deed is unregistered or whether it is a valid document. Contents, date and signature of judgment. The judgment of the applicant shall be in writing and shall state the points for determination. There is no any determination. The decisions thereof, the reasons for the decisions, and whether decree appeal from its reverse or varied. Your Honor, if it is concurrent judgment, that is a different. But if the appellate court reverse it, then it is a different thing. The relief to sought which the appellant is entitled and shall at the time that is propounded be signed and dated by the judge or the judges concurring therein. It is a well settled that the first appellate court shall state the points for determination, the decision thereon, and the reasons for decision. However, it is equally well settled that mere omission to frame points for determination does not vitiate the judgment of the first appellate court, provided that the first appellate court records a reason based on evidence adduced by both parties. If you are not to go through the appellate, there is no any discussion regarding the evidence. An appellate court is the final court of facts, Your Lordship. And second appeal, High Court is a facts of law, Your Lordship. Final court of law. So first appellate court is a facts of law. Judgment has to be on facts, Your Lordship. Judgment of the appellate court must therefore reflect the court's application of mind and record its findings supported by reasons. The law relating to powers and duties of the first appellate court is well forfeited by the legal provision and judicial pronouncements. Considering the nature and scope of duty of the first appellate court in Binod Kumar versus Gangadhar, it was held as under that in Santos, Hazari and Purushottam, this court has held as under that the appellate court has jurisdiction to reverse or affirm the findings of the trial court.
Okay, okay. There is no dispute about the legal
Yes,
proposition
Your Lordship.
that has been laid down in this case.
So that error
Uh,
has been created by the
It is a fact that in
Your Honor,
the
two substantial question has been framed to that effect. Whether the first appellate commits any illegality in rejecting the trial court's finding for compulsory registration of an instrument of value of 100 and upward in deciding the issue number 4.
Mm.
Complete illegality has been done, Your Honor, without any discussion, without any findings that compulsory registration is required.
Mm.
And number 2, substantial question, whether the first appellate court committed illegality deciding the suit on the basis of a mortgage deed and registration receipt in the absence of a valid sale deed. You know, on every legal person is aware that on a mortgage deed, sale cannot be given, cannot be transferred, property cannot be transferred. So this first appellate court committed in deciding the suit on merit on the basis of it decided the suit on the mortgage deed on the registration receipt in the absence of a valid sale deed. These two substantial questions has been framed, Your Lordship. So my humble submission before this honorable court that the trial court judgment should be upheld, Your Honor. The appellate court judgment has to be set aside. And the as per their submission that they have taken position on the basis of by misleading the on the basis of an unregistered deed, they have taken possession. Now they are only a trespasser, Your Lordship. How they can, if they have a valid title, Your Honor, I have nothing to say, Your Lordship. They have a right to take possession. How they can mislead the court, executing court, that they have a title, they take into a position by disposing us. So their suit is based on title and position. So they should go.
Before execution of the decree, no notice was issued to you.
That itself is some error thing.
Whether any stay order was passed in this?
Not required. It is before 2 years, my lord.
So
My
that
friend is very well.
so yes, that is also why if they have
No.
my submission is that if they are rightful owner of this suit land, why couldn't they wait for this appeal, second appeal? So that intention is there to dispose us, which we have been possessing here.
Whether any stay was granted in this appeal?
Yes, there is a stay.
Then how can it was executed?
Yes, prior to this stay, they have executed. That's illegality has been done. That's why I am stating, Your Lordship. If they have a rightful owner, why didn't they wait for that second appeal? In a very limited time, they have gone in a very forced manner and they have evicted us. So that illegality has been done. So without having valid title over the suit land, Your Lordship. And the wrongdoer cannot be entertained, Your Lordship.
When the stay was granted? Is there any
Yes, Your Lordship. It is on 15/3/10, Your Lordship. After hearing the land appearing for the party, it is provided the status quo as on today with regard to possession of the land and house in shall be maintained. So, Your Lordship, all these things has been done by the plaintiff behind the back.
And when the decree was executed?
But executed by 16/6/2009.
So that's why
Before that, the order has been passed. It says by the decree holder by Nazira. The writ was issued return after the execution with a report. Peruse the report of the Nazir. The possession of the dictated land was delivered to decree holder on 29/5/2009.
No, that's all right. Then whether it was not your duty to point it out to the court that a
Hello?
decree has already been executed? Because when council entered appearance for the respondents
Yes.
When, my lord?
on 15/3/2010,
Maybe through wakalatnama, my lord.
pardon?
Maybe through wakalatnama. On,
Yes, advocates always appear by filing their wakalatnama.
no, my lord, on that day, I think the case was not listed before. On subsequent date, why that has not been pointed out?
Your lordship, advocate were also present for the respondent on that day.
Anyway, your part is over.
Yes, and
Okay, please.
First and foremost, my learned friend has submitted that the decree has been illegally executed. It cannot be said, my lord, it has been illegally executed. It has
No,
been-
no,
my
no,
lord,
no.
I'll come to the facts and I'll come to the law also.
Oh,
It cannot be said it's been illegally executed. Only because, my lord, a decree has been obtained. A first appellate court, a decree has been passed. On the basis of the decree has been executed. Before that also, my lord, they have filed an application under 47 before the executing court, which has been rejected. After that, my lord, the question of giving notice also does not arise because it was within the 2 years. Now, my lord, if your lordship come to the place, my lord, it happened.
yes.
My lord, claim, my lord, it was a suit for declaration and recovery of position and injunction.
Page number? Yes, 31.
This for it.
Hmm. It was a suit for declaration and recovery of position. Mm.
My lord, if your lordship comes to the prayer court, it says, my lord, it's place for a decree. Declaration of right title and basis over the suit land. For recovery and khas possession of the suit land by evading the defendants, his men, agents, servants, and all from the suit land. This is important, my lord. And for permanent injunction restraining the defendants from construction of any structure or the suit land or any or in any number encumbering the said. And for rupees 50,000 being value of the demolition house as compensation and any other reliefs to which the plaintiffs may be entitled. On this prayer, my lord, suit has been dismissed, referred in appeal, and appellate court has allowed the appeal and a decree has been passed. On the basis of decree for the recovery and delivery of cash possession of the suit land, out of the decreed land has been handed over to us. Now, my lord, if your lordship come to the first and foremost, my lord, the judgment of the trial court, my lord. This is an appeal preferred by the appellant plaintiff challenging the কিমান আছে পেজটো? First appellate.
Yes.
Passed by the judgment and decree dated 35/2007, passed by Smithy B. Khetri, London, Nochi number 2, Gauhati, in title suit 249. New and title suit 2/90 all dismissing the suit of the plaintiff by the London. Not this color. Trial court, Mala, I'm sorry, but. This is suit for declaration and recovery of position. But the plaintiff case is briefed that one suggested that mortgages a 10 Lessa on 1974, a Lessa block land with 4-room house with kitchen plaintiff for 3 years for consideration of 2,500 and delivered the possession same to the plaintiff on condition
in default of payment of the amount with interest 10% per month with stipulated time. 10 lesser of house will vested in the plaintiff mortgagee. The land is described in the suit land in the schedule. After taking over the position of the suit land, the plaintiff started living in the one room of the said house and let out the other rooms to the tenants. The plaintiff paid municipal taxes for the house bearing holding 26 Ward 19 of GMC. Thereafter, the said Sadeshwar Das mortgager fell seriously ill and been in urgent need of money for treatment. He offered to sell the suit land. Sadeshwar Das sold the land to the plaintiff for a consideration of 70,000 and executed a sale deed in favor of the plaintiff on 5/11 to 1974. My lord, this is also important. Executed and sale deed in favor of the plaintiff on 5/11, 1974, my lord. And presented the same for registration in the office of the sub-registrar Gauhati. As the area of 10 lesser was small, the sub-registrar declined to register the same and kept the same pending by receipt dated 1051, dated 5/11/74. This is our case. We have already stated, my lord, the sale deed could not take places due to the 10 lesser of land as told by the sub-registrar, but a receipt to that effect has been there and which has been exhibited and duly proved by the plaintiff in a trial court. Now, my lord, first and foremost, my lord,
No.
I'm coming, my lord.
Is there any provision which prohibit the register to register a sale deed if the land falls below 10 lesses?
My lord, that is at that time. So, my lord, exactly this is our case. Now, my lord, how we have proved this case, I'm coming, my lord. To that point, my lord.
No. You
Now,
answer my
It will
question.
take hardly 10-15 minutes only, my lord. If your lordship come after that, my lord. In the meantime, during pendency of the register matter, the said Sadeshwar Das mortgager died, leaving behind no heirs. No heirs, my lord. Thereafter, the plaintiff left the room in which he was living and shifted to his paternal house in Kumapara, Gauhati and let out the sale. Thereafter, one chief Potol Das tenant reported on 9/2/88 about 7:30 p.m. that Bipul Das defendant with his brother and 7-8 men forcefully entered the room occupied by him by throwing out his belongings. The occurrence was reported to the Horlumuk PS and the police registered a case under 107 CRPC which is pending. On 12/12/88, the defendant started demolishing a house down by engaging some men. When the plaintiff reported the matter to the police accompanied by the plaintiff came to the place of the occurrence and found the demolition of the house almost complete and defendant had raised brick wall to the height of 5.5 feet. The police asked the defendant not to proceed with further construction. But after the police left, the defendant complete construction and took over the complete position of the suit land by demolishing the whole house, causing great loss and injury to the plaintiff. The defendant has collected materials to construct a new structure on the land. Hence, this suit to restrain and prohibit the defendant from constructing any structure or house on the suit land. The defendants appeared and contested the suit by filing written statement. The written statement on behalf of the minor defendant number 2 have been filed by the guardian at Lytton, appointed by the court. In their written statement, the defendant has stated that there is no cause of action for the suit. The suit is barred by law of limitation. But for non-joinder of the necessary parties, the heirs and legal representatives of Sadeshwar Das has not been made party in the instant suit. The heirs of the legal representative of late Sadeshwar Das. This is also important, my lord. Written statement.
Your lordship, that was also a very important.
Please sit down.
Yes.
Let him complete.
Yes.
Let me complete it. The suit of the land was and the house was never in possession of the plaintiff, and there is no occasion for the late Sadeshwar Das to mortgage the land and the house in the favor of the plaintiff. It is stated that late Sivaram Das, the father-in-law of the defendant, possessed and occupied the suit land and house prior to the 1970s. Well, this is also Sivaram Das occupied and possesses the suit land prior to the 1974, and is after his death, his son Bipul Das, since the case, husband of the defendant number 1 and father of the minor defendant number 3, possess and occupy the said house in an uninterrupted manner, and after his death, present defendants have been possessing and occupying the said land. The house standing on the 10 lesser of the suit land was constructed by the late Sadeshwar Das many decades ago, and the same got damages and dilapidated due to the wear and tear. The defendant number 1 and her husband, late Vipul Das, rebuilt and renovated the the said house in 1998. 1998 about 88 most probably. And his house stayed on a plot of the land measuring 16 lessas covered by the dark number 1279 12821 old 661 new respectively of KP Pata 231 old 792 old. Out of the 16 lessas of land, 6 lessas of land devolved upon late Vipul Das after the date of Sivaram Das, my lord. This is devolved upon the date of Sivaram Das and after date of Vipul Das death, said land is devolved upon the defendant. 16 lessas of land, my lord. 6 lessas devolved upon them. It is there with this statement. The remaining 10 lessas of the hell was standing there in position of the late Vipul Das since the lifetime of late Sadeshwar Das. This is also important, my lord. Was in possession of the late since standing in possession of the late Vipul Das since lifetime of Sadeshwar Das and his death, the defendants were in possession till today. Late Vipul Das paid rent revenue and other taxes and is occupying the one room of the said house, and other rooms were let to other tenants. Let to other tenants, my lord. This is also important, my lord. The plaintiffs were never in possession or occupation of the suit land as well as the house standing thereon, and late Sadeshwar Das was also not in occupation or possession of the aforesaid house during lifetime. The defendants have further stated that the late Sadeshwar Das has been suffering from ailment of leprosy and allied disgraces since before 1974, and late Sivaram Das and late Vipul Das took care of him. It is denied that Sadeshwar Das executed the sale deed in favor of the plaintiff on 5/11/74 and presented the same for before the sub-register Gauhati. It is stated that Potol Das was the tenant under the defendants, but predecessor in interest. This is also important, my lord. Potol Das, this name, my lord. Predecessor in interest late Vipul Das, and he vacated a room in favor of him by executing a deed. The plaintiff has no manner right, title, and interest over the suit land, and the suit is liable to be dismissed on perusal of the pleadings, my lord. The 8 issues your friend. Number 1, what are the cause of action, barred by limitation, the non-joinder of necessary parties, right, title, interest over the suit land. Plaintiff was in possession of the suit land, protected right of adverse possession as played for decree, and what other reliefs. Number, my lord, in this case, my lord, of this issue, they have filed a written statement, my lord, whether the plaintiff was in possession of the suit land and a defendant is disposed of the suit land, and whether plaintiff was the right, title, and interest. These two are will be the necessary issues, my lord, to determine the present list, my lord. Now, first and foremost, my lord, whether the defendants are protected by the right of adverse possession. Possession of adverse possession will come, my lord. This, I don't know how this issue has cropped up. Once, and my lord, counterclaim comes. In the present case, we have seen, my lord, they have filed a written statement. There was no counterclaim to the effect that they are seeking an title or interest by the way of adverse possession. Because if a lordship come to their written statement, my lord, it says, my lord, again, my lord, it says, this year, my lord, out of the 16 lessors of land, 6 lessors of land devolved upon late Vipul Das after the death of Lord Sivaram Das and after the death of Vipul Das, the said land devolves upon the defendant. It is an admitted fact, my lord, there are 16 lessors of land. 10 lessors of lands. Our case was in our possession through a mortgage deed, through an unregistered sale deed till 1998. 1998, we has been dispossessed, which compel us to file this suit with a prayer for the recovery of possession. It could have been an admitted case where the plaintiff should not have been decreed had there has been no prayer for the recovery of possession, my lord. Had there has been no prayer for the recovery of possession, my suit should be not maintainable. Consequential relief, if not prayed for, then my suit should not be maintainable. Now, here, the dear written statement itself says, my lord, only 6 lessees of land devolve upon late people thus.
No, Mr. Das, you say, this court is not entitled to appreciate the facts in the second appeal. We have to confine our discussion only in respect of the substantial question of law framed by this court. You come to the substantial question of law, whether
My lord-
these questions
lord,
are involved here
no.
or not.
No, my lord, what I'm stating, I'm stating from the judgment itself. my lord.
Pardon?
What I'm stating, I'm stating from the judgment itself.
Hmm.
Just what has been stated in the judgment,
Hmm.
I'm making my submission from that only, my lord.
Hmm.
Because while when passing the judgment by the learned trial court, my lord,
Hmm.
I said. While passing the judgment by the trial court, some important aspect has not been taken into consideration, which force us or compel us to file the appellate first appeal, which has been allowed by the learned first appellate court.
Hmm.
Being agreed, they filed this. Now it's my duty to present before you the proof facts as well as the taking into law pen. Law pens I will come, my lord. Section 114G of the Evidence Act will also come, my lord. We
No,
have,
no,
no, we have
not-
filed 4 evidence, my lord. No, my lord. It says, I have not, why I am coming, my lord. Findings of the trial court also I'll come, my lord. It says, my lord, for a time being, my lord. Otherwise, at 2 I will present. It says, my lord, furthermore, according to one portal das was a tenant in the house standing over the suit land, inform him on 9 to 88 about something the defendant along with his forcefully entered in the room occupied by 3 out his building, but the plaintiff has failed to examine the said petaldas to prove that he was dispossessed from the suit land. The trial court came into a finding of this, but what about the other 4 evidences?
Hmm.
That has been stayed only because they failed to counter it through and cross examination, my lord. That also has to be taken into account.
Hmm.
That's why, my lord, the trial court judgment is also important.
Hmm. No, no. That is important. That is a different matter, but we have to confine our.
Yes, I'll do.
Uh,
I'll do.
only
I'll do.
upon
Hardly-
this substantial question of
Yes,
law.
Mala,
these two.
I'll take hardly 15 minutes, man.
Hmm.
Better that substantial case is mental level in the present.
Okay,
At 2, my lord.
at two.
Before the lawsuit rises, madam, I have, yeah, madam, earlier item 39.
Item number?
Here, madam.
Item number?
39. Due to some urgency, madam, I have to leave to post one of my visitors, madam. Item 39, I am for the respondent.
On the pair being made by Mr. M.K. Misra, learned counsel for the respondent number 1, 2, and 3. And having not been opposed by Ms. Murtaza, learned counsel for the appellant, the matter stands adjourned to be listed after.
Kindly a short deed may be given, my lord.
After 1 week. 1 week or 2
After
weeks.
1 and 1.
Oblige.
I want to take little liberty in item number 31. Lordship, this matter is led by my senior Shri Kiran Chaudhary. He has some difficulty in second half. Lordship, may I pray to take up this matter in first week of June, Lordship?
Item number?
31.
31, I appear for the.
Respondent, I am
My
for the petition.
problem is that I have come all the way from Delhi. And this
Okay.
is for the 3rd time they have sought adjournment.
I don't know, last occasion.
Last occasion I took because I was injured, I broken my hand. Lordship, but I had actually interacted with Mr. Chaudhary today also. In another court, he has taken time for 7 June, 7 May. Lordship. If it is possible. can
No,
you-
7 May, Lordship, he will not be available for.
No, he himself has taken time for 7th
No,
May in a PIL. I appear also in that matter. That's
7
why-
May is not possible, Lordship. As per instruction of my senior, you have.
Because
to
I
take
was there in
five
other
Ju-
court, he was also there in the same matter,
Because,
PIL.
from,
So he also sought time up for 7
No,
May.
okay, you settle the issue between yourselves. You apprise this
See,
court,
what
accordingly
else-
we will
First
fix
week of-
fix
Can you
it.
give me the liberty to argue my part today in post lunch?
Post lunch,
today,
your item is 31.
31.
It may not reach today.
Lordship, in that case,
Because,
I'll be asking for a shorter date, Lordship.
Yes. It may not reach because these are all second appeal.
Lordship, it's fine, then I will be requesting for a shorter date, not in June, Lordship.
Okay, then last part in May. You take it that from him as per your convenience.
Yes.
Much better.
May
Yes,
I
any
please,
other?
Your Lordship, in item number 26, Your Lordship, substitution petition has been filed.
Hmm.
It has not been tagged, Your Lordship. So one week time may be given, Your Lordship. It will come in the orders column, Your Lordship. Substitution petition has been filed. It has not been tagged.
You are for the appellant.
No, Lordship, I'm for the response, I'm for the legal aid or response, but response number 3, Your Lordship.
Okay.
Apparently, there is a defective petition, Lordship, it will be cured, it will take some time. So it may come accordingly, it may come in due course with the RNC, Lordship.
Okay. As agreed by learned advocates of both the parties, this is at least the matter. After a week or 2 weeks?
1 week time is okay. It will come in the order column.
After a week.
That's all, Lordship.
Okay.
Yeah, please, Your Lordship.
Yes.
Lordship, I beg your pardon here. Lordship, I beg to mention item number 30, Lordship. We have taken the consent and already informed, sir. Lordship,
30.
30. I'm for respondent 1. For respondent.
Okay. As agreed by learned advocates of both the parties, this is at least the matter. After?
Lordship, execution proceeding on 28th of May. On that date can be fixed, Lordship. 28th of May.
Before that day.
Not on that day, because 18 and 19 days a problem on convenience. Lordship, on that day, 28th of May.
Okay.
29 go.
20. 20.
Wednesday, hearing made on Wednesday, not possible.
Execution proceeding on that day only. 19 days are difficult, 18 and 19, before that day.
Hearing day, Lordship. Hearing made on Wednesday.
Before that.
No, not Wednesday.
Lordship, before that, before 28th of May. Before 18 and 19 days are problem, other side has problem. Lordship. Not so much.
Yes.
I'll take 15 minutes, madam. Only 15 minutes I'll take. 8 issues have been premed. Issues are important, that's why I'm pointing out, my lord. 4 and 5 is the main issue, my lord. Right title. And with regard to that, if your losses come to the trial court for time being, my lord. Trial court, my lord. Issue number 4 and 5, para 7.
Yes.
Para 7, it says, according to the plaintiff, one subject does mortgages on 24/7, 10 Lessa block along with a 4-room house for him for 3 hours for consideration of rupees 2005 and delivered the possession of the same. Thereafter, being need of the urgent money, sold the same to the plaintiff for consideration of 70,000 and executed the sale deed in favor of the plaintiff on 5/11/74. Presented, this should be, my lord, unregistered sale deed. Executed, it should be unregistered and presented the same for registration in the office of the sub-registrar Gauhati. According to the plaintiff, as the area of the 10 lessor was small, sub-registrar declined to register the same and kept it pending as exhibit 1. Exhibit 1 is the copy of the sale deed executed by the solicitor in favor of the plaintiff. It is not a sale deed, my lord, this is a mortgage deed. This is an
Exhibit
act, my lord.
1 is mortgage deed.
Yes, it's a mortgage deed, and I'll come to that mortgage deed, my lord. Exhibit 1 is a mortgage, it's not a sale deed. And 2 is the receipt of the sub-register office, of who is the, my lord, the sale deed could not be executed. As per section 17 of the Registration Act, decision admitted fact, my lord, the law itself says, anything it should be registered. But it appears that amount is 25,000, no compulsory, my lord. I'll skip that part. My lord, I'll come to the, my lord, furthermore, according to the plaintiff, one Patal Das, who was a tenant in the house standing over the suit land, informed him on 9/2/88 about 7:30 p.m. The defendant, along with his brothers, forcefully entered into a room occupied by him and threw out his belongings. But the plaintiff has failed to examine the said Patal Das to prove that he was dispossessed from the suit lands. But my lord, there are four evidence. There are other four evidence, and there was the exhibit one, which is a mortgage deed, itself says that it is a delivery of possession. The learned trial court failed to appreciate all those pleadings and came to a wrong finding, my lord. And to cut, there are no evidence from the defendant side to prove that they were protected by right of adverse possession. The suit is decided in a negative. Like it says, my lord, since the plaintiff has failed to prove his right title, interest, and possession of the suit land, and is alleged disposed from the suit land, so there is no cause of action. There is no cause of action for the suit, and the question of suit begin barred by limitation does not arise. My lord, our case is through the mortgage deed. That is the exhibit one, my lord. That mortgage deed was never challenged by any of the legal heirs of the late correspondence, or neither by the defendants. It will have to bear the, my lord, evidentiary value, because it says, my lord, it says that top sheet of Dosrota Mati Jasi Dilu. If your lordship go to the records, it will be exhibit one. If your lordship going further, yeah. Baku purwa sir. এখানে পড়বে।
মোট ধার পরিশোধ করার মোট ধার পরিশোধ করার ভাবে আর মোট ঘর পরিচালনা করার ভাবে উপরোক্ত বরাবরের পরামর্শ নগদ 25 টাকা ধার 25 টাকা ধার হিসাবে টকা ধার লই অধিকার করিল অস্বীকার করিলে যে উক্ত টকার সুদ মাহে মাহে করা 10,000 টাকা হিসাবে ধার্য করিব। উক্ত বিচার উক্ত টাকার জামিন বাবদ উক্ত টাকার জামিন বাবদ মোর
Where is the original document?
Well, that has been exhibited already.
No, this is not legible.
My also, it's not legible, my lord. That's why
Then how can I go through it?
because it was evidence is in the trial court, my lord. The trial court had accepted this and no one has ever put any, my lord, question with regard to.
No, that is a trial court discussion.
Yes.
But
At this present, my lord, I am also, it is an, I'm also finding it
Then-
hard to read it, my lord.
then
But the mortgage deed says the topsil or Doslosa Mati Jomin to the Jasi Dile. My position has been delivered. My position has been delivered. Why I mean to this, my position has been delivered. Dear pleadings to the effect that we are never in position, this itself will show. This itself will show that my position has been delivered.
no, you produce this original document.
Original one, my lord.
Your Honor, in this case, regarding this document, there was no any statement to the effect in the mortgage deed that there is any delivery of possession, Your Honor. It has been written in the mortgage deed. I have gone through it, Your Honor. So they, in the
Whether
learned
the
counsel,
legible copy is available with you?
no, I have translated very hardly for my reading, Your Lordship.
For your
I have
reading.
translated also for my study. There is no delivery. There is no delivery of possession has been stated. If your
I'll try
lord,
to find out, my lord. I'll contact.
your
If
lordship-
your lordship want the original one, I'll contact with my clients, my lord. Can it be taken after some days, my lord?
your lordship, if they are aggrieved, they have already prepared an appeal, your lordship, and this honorable court is only confined with the appellate decree, your lordship.
Yes, yes, yes.
He is reversing back to the trial.
No, my lord.
So
Because,
he is stating his own, that he said trial court judgment is wrong.
You have completed your argument.
Yes, yes, yes.
After completion of his argument, you will get a
A
chance to reply.
Yes, yes.
yes, my lord, the trial court judgment is wrong. That's why he preferred an appeal.
Mm.
First appellate. If your lordship wants to go for this.
No,
original-
you see, from this document, it is difficult to.
My lord, I'll try to find out. Can it be after some days, my lord? 2-3 দিনৰ যেতিয়া because the parties are from Gauhati itself, my lord.
Okay. Let them produce the original. your
Because
lord.
it also hard in
If
length for-
court directs, if enable. They free.
Third, Mr. Your name, please.
Partha Chaudhary.
Learned counsel for the appellant. And Mr. Das for the respondent. Heard in part. List the matter after copy.
Mongol
Fixed date.
Mandal.
Last week, 28 May.
And in the meantime, Mr. Das, learned counsel for the respondent, has produced the original copy of the exhibit 1.
My lord.
Original copy of the mortgage deed, which was exhibited before the learned trial court as exhibit 1.
My.
Whether any other documents are there?
Exhibit 2 is a receipt of the would be sent, the sentence could not take place.
Hmm.
And third is the unregistered. Sale is-
Is this mortgage deed is a registered document?
Yes, 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 it is.
Article five.
Here is my lord,
28 তারিখ করবেন। 21 জানি না, sir।
305 gate number, my lord.
Okay, okay. List on 28 as part of.
Okay, 25 of okay.
Item 24.
Alright.
Please, Your Lordship.
Hmm.
The item 24, the opposite party, my friend Prohidul Islam was earlier appeared. Because of illness, he was perhaps not present. My lord,
You have seen him today, no?
no, I have not seen him. He was not bedridden because of some problem, my lord. He
Okay.
could not attend court last 6 to 7 months, he could not come, my lord. I think that some alternative arrangement is there, my lord. That I am also, otherwise, my lord, I have some urgency. May you, my lord, lordship may, next week or my lord, on next, may defer once, my lord.
Last part of May. Heard Mr. C. Goswami, learned counsel for
14, my lord, of 21, my lord, my learned friend also
the
may come, my lord.
for the respondent on call.
14 or 21, my lord.
Okay. This is a list the matter on 21st of May.
My lord. In the meantime, I will inform, my lord, if may some alternative arrangement be done.
Okay.
Item 25.
Oh,
This appeal is against a judgment of reversal. We are for the plaintiff appellant. Our suit was decreed by the trial court. On appeal, the judgment was reversed. Trial court judgment, Lord, you will find at page 33. Now, one substantial question of law was framed. And that is whether the learned first appellate court is correct in concluding that the annual patta land standing in the name of Bihali Kosari was annulled owing to the gift made to the appellant by the said, Bihali Kochari. Possibly, my lord, one more substantial question of law will be necessary.
Mm.
Because if your lordship, I'm just pointing out in short, my lord, if your lordship goes to the plaint, which your lordship will find at page 10, I'm sorry, it's page 11.
Mm.
Lordship will see the plaintiff is Muhammad Habib Dhunia,
Mm.
and the defendants are number 1, State of Assam, number 2, subdivisional officer, and number 3 is the private respondent, and 4 and 5 are also Latmandal and supervisor Kanungo.
Mm.
If your lordship goes to the prayer portion at page 15, the relief sought is number 1, declaration that the plaintiff has right, title, and interest over the suit land by dint of adverse possession. Number 2, cancellation of order dated 2/8/2008 passed by the circle officer Jonai in revenue case number so and so. And number 3, declaration that correction chita by Latmandal, that is defendant number 4, suo as illegal and to be recorrected by inserting name of plaintiff in place of defendant number 3. And 4 is ejectment of defendant number 3 and delivery of possession of the suit land and house to the plaintiff. Now, the relief of number 1 also, 2, 3, and 2 and 3, 1, 2, 3, my lord. These are the reliefs primarily sought against the state. Plaintiff has filed the suit, my lord, specifically asserting that it is a Toji Bahira land, government land, khas land. Now he has prayed for a decree of declaration of title by adverse possession. More particularly, 2 and 3 are very specific orders passed by the circle officer and the correction chita by Latmandan. These are the reliefs sought against the government. Now, that is why government is a defendant here. Now, when the suit was decreed, the appeal was filed. Fortunately, my lord, normally memo of appeal in the before the learned first appeal court is not required to be annexed, but in this case, it was annexed. Page 57 is the memo of appeal, if your lordship kindly goes. Defendant number 3 has preferred this. Suit was decreed, my lord. Defendant number 3, which is the private party, has preferred the appeal.
Page number 50?
57, my lord, 57.
Mm.
Lordship will find in the cause title, defendant number 3 is the appellant and plaintiff is the respondent.
Mm.
And these state respondents were not made parties. Now,
In appeal.
in appeal. Now, question will arise whether this appeal will be maintainable for non-joinder of necessary parties. Defendant number 1, 2, 4, 5 are necessary parties considering the prayer made in the plaint.
Mm.
Suit was decreed.
Mm.
If your lordship goes to the trial court judgment, my lord, which starts from page 33
Mm.
and page 49 is the
Whether the state respondents have contested the proceeding before the trial court?
yes, ma'am.
Written statement filed.
You are for?
I put it, responded by the.
My lord, written statement filed and
Respondent
evidence
number?
there.
Respondent matter Habib Dhunia.
Okay.
This is the private respondent.
Private respondent.
No, my lord, the government has contested the suit, my lord.
Mm.
They have not only filed written statement, they have examined a witness also.
Mm.
If your lordship goes to, I'll just show my
Mm.
page. My lord, page 51, lordship will find. Page 51, my lord.
Mm.
Page 51, list of plaintiffs' witnesses, defendant witnesses are given. Lordship will find under the heading defendants' witnesses, witnesses of defendant number 3, DW 1, 2, 3, 4, and 5. Witness of the state defendants, DW 1, Sri Rajesh Pegu, who was the Lat Mandal. At page 42, his name is mentioned, DW 1, Sri Rajesh Pegu, who is the Lat Mandal. Deposed as per direction of the circle officer, June 9. Page 42, madam. Paragraph 36. So at this stage, madam, I am only saying that possibly this substantial question of law will be necessary, subject to what my learned friend says.
Then I will argue, my lord. But I am also suggesting one substantial question of law, my lord. That matter whether in absence of any pleading for evidence of record, the requisite precaution of adverse person, a degree of adverse person can be passed in favor of the applicant, my lord. That may be also
It is our appeal. He will have to file an appeal to suggest a substantial question of law.
This is against my reversal, my lord. My contention is that, my lord.
No, maybe if at the time of hearing it is found necessary, then it is a different matter, not at this stage.
My lord. My lord, this my learned senior friend who is arguing, my lord, that the non-joinder, my lord, whether that plea was taken in the memo of appeal or not, but that will be considered.
No,
No,
this question has
Mr.
come up in the appeal only. In the plaint, we should not take, because plaint, we made them parties.
In the second appeal, memo of appeal, my lord.
No. In
Whether
the
that ground was taken or not, or my lord, while admitting the appeal, my lord, that non-joinder of plea was before this honorable court or not, that has to be considered, my lord. Because
What?
at this stage, my lord, they cannot take the plea, my lord. My
Which one?
submission, my lord. What I'm saying, my lord, they have filed appeal, my lord, second appeal, my lord. Some grounds were
No.
stated, my lord.
You prefer the
I prefer
first
that.
appeal.
Yes, my lord.
In first appeal, you have not implemented the state respondents.
State respondent, my lord. Because in the original suit, my lord, I was the defendant, my lord. The relief was sought for against me, my lord, my lord, prayer number 1, my lord. The adverse position, my lord, and my recovery and ejectment, my lord. On being
No,
my lord, I have prepared an appeal, my lord. I have no grievances against the, my lord, respondent, the state respondents, my lord. That is why, my lord, he was, the state respondents were not made party, my lord. But that appeal was disposed of by reversing the judgment of the land trial court, my lord. There was no plea was taken during the argument of this first appeal, my lord. In the second appeal, my lord, when they preferred the second appeal, my lord, in the memo of appeal, they have stated some grounds, my lord. The grounds I have said, my lord, that ground is not there, my lord. In substantial question of law also, my lord, that was not there, my lord. They are suggesting this substantial question of laws, my lord. Then when, my lord, admitting the appeal, my lord, that, my lord, substantial question of law not there, my lord, the grounds were also not there, my lord. But at this stage, my lord, whether, my lord, my learned friend is maybe permitted or not, my lord, that will be, my lord, arguing in the next step, my lord, whether it is permissible or not, my lord.
no. In the order of admitting appeal,
Yes, my lord.
it's also reflected that the court may consider framing of any other substantial question of law if found necessary at the time of hearing.
Yes, my lord. That always can, my lord. But,
Yes.
the new plea has been
Where is
taken
the
by us today, my lord. That I have gone through, my lord, whether they may be it is permissible for the appellant to take a plea of non-joinder at the second appeal stage, my lord. As no ground was set forth in the memo of appeal, my lord.
No, appeal was preferred by you
First
before
appeal
the
was
appellate
preferred by
court.
me, my lord.
Yes.
Because I have no grievances against the state respondents, my lord. Can you see the prayer, my lord? In page 49, my lord, the trial for custom, my lord. What is the decree, my lord?
Mm.
Page 49, I will-
No, whether no relief was granted against the state respondent.
No, my lord. In fact, my lord, if your lordship say peruse the evidence on record, my lord, the entire suit is something is defined, my lord. The government land, which was, my lord, that transferred, that was, possessory right was transferred to my wife, my lord, not me, my lord. The whole structure of the suit is, my lord, bad, my lord. If your lordship, my lord, one exhibit, my lord. Exhibit D, my lord. Matri Bikki Nama.
Mm.
It is not in favor of the present respondent also, my lord.
No, you see, in the judgment,
Yes, my lord.
the order of the circle officer dated 2nd of August 2008 is set aside.
Yes, my lord. It is only mutation order was set aside, my lord.
No, not set aside. It is declared as illegal.
Illegal. Only the mutation order was declared, my lord. But my position, my lord, position was interfered, my lord. And the right title and interest of the suitland was given in the sortai land, my lord.
Mm. So, Mr. Mojumdar, you say it is a well settled in several decisions of the Supreme Court, including in the decision of the Pasugopal Borua and Umakanto Sharma, that no new plea can be raised in the second appeal. So, can you at this stage you raise that plea now?
My lord, here we have preferred an appeal against the judgment and decree passed by the first appellate court.
Mm.
Now, so far as first appeal is concerned,
Mm.
that appeal was preferred by them.
Mm.
Now, relief that was granted,
Mm.
if your lordship looks at the relief,
Mm.
and I'm just pointing out the relief, lordship
Mm.
kindly see the last page of the judgment.
Mm.
My lord, trial court judgment, if your lordship goes to page
49.
Yes.
49 is the order.
Yes.
51.
Yes.
Paragraph number.
Yes. Now at page 50, you will find, starting from page 49, paragraph 52.
Mm.
Accordingly, it is declared that the plaintiff has got a right title and interest over the suit land.
Mm.
So this declaration of title, the land being a Toji Bahira land and Khas land admittedly, is against the state.
Mm.
That is why state is a necessary party and state, I have made state a party.
Mm.
Now they have preferred an appeal. Now in the appeal, they do not make state a party, whether it is not a case of non-joinder of necessary party. Not only that, para 50, Lordship, you kindly see, para 50.
Mm.
From the foregoing discussions and decisions arrived at issues number 1, 2, 3, 4, 5, 6, 8, and 9. It appears that all these vital issues are decided in favor of the plaintiff. So all the issues, including the issue on the point as to whether the Chitha correction and relief number 1, 2, 3, all are decreed.
Mm. So your plea is not a new plea.
No, not at all, my lord.
Mm.
You have preferred an appeal. Before the trial court, there is no question of taking this plea.
Mm.
Trial court, I filed a suit making all these parties as defendants because they are all necessary parties.
Mm.
Appeal was preferred by you.
Mm.
And in the appeal, you have not made the state government a party.
Mm.
because state government is a necessary party so far as suit is concerned.
Mm.
You have filed an appeal against me, but your grievance, you are also saying that you are the owner. My lord, although they have produced one agreement to sell, but they are pleased that they have become owner because it is a sale deed.
Mm.
So going by your defense also in the state, in the suit, state government is a necessary party because both the parties agree that it is a Toji Bahira land.
Mm.
Now, state government has not been made a party in the appeal. The question is, therefore, whether the appeal is maintainable for not impeding state respondent. And what I'm saying is, when section 100 of the Civil Procedure Code says,
Mm.
proviso, my lord,
Mm-hmm.
provide after subsection 5,
Mm.
provided that nothing in this subsection shall be deemed to take away or abridge the power of the court to hear, for reasons to be recorded, the appeal on any other substantial question of law not formulated by it, if it is satisfied that the case involves such question of law.
Yes, sir.
So if your lordship frames today,
Mm.
they are at liberty to argue that now it is not involved. Like we argue, my lord, as a
Mm.
defendant, that appellant has suggested, court is framed a substantial question of law, but after that the respondent argues that this substantial question of law is not involved because of these submissions.
Mm.
They have a right to argue like that, but then in my humble submission, that point has to be decided. And that is why I say that it may be framed today. They have got a right to argue that it is not involved because you have not taken plea, these, that. But factually, it's a suit where in a government plot of land, I have not only prayed for declaration of title by adverse position, I have also challenged 2 orders passed by the 2 government officials. Therefore, I have made those government officials a party, including the state government.
Mm.
Now, when the appeal was preferred,
Mm.
in the appeal, those necessary parties were not made parties in the appeal. That is why the question arises without their presence in the proceeding, whether the appeal would be maintainable. That is the question I am praying, subject to your lordship consideration. My lord, court can frame by recording reason.
My lord, with all respect to my learned senior, my lord, with your lordship sees the prayer, my lord. Now, prayer number 1, my lord.
Mm.
By way of right title and interest of what is suitland by dictate of adverse person. Against whom, my lord? Against me or my lord state? If the state, my lord, then where is the pleading for adverse person, my lord? 30 years, my lord, no pleading in the plain, my lord.
But
if against me, my lord, then I became the owner, my lord, rightful owner, my lord. I'm the owner of this land, my lord. Then where is the, my lord, the description of the 12 years of limitation?
The land was annual patta land.
Annual patta land. That was possessory right was transferred, my lord.
Mm.
Rightly or wrongly, my lord, the circular which are inserted my name in the record of rights, my lord. That
Mm.
was, my lord, that was come, my lord, in the trial court judgment, my lord.
No, no.
My possessory right is there, my lord.
Mr. Bhuya,
Yes,
you
my lord.
see,
Yes, my lord.
that will be considered at the time of hearing.
Yes, my lord.
But apparently, it appears that the state respondents are not implemented in the appeal.
Appeal, my lord.
So let there be one substantial question of law on
Yes,
this
my
point. I do not think you have any objection on this point.
My lord, when my lord.
Because it also cannot be said that it is a new thing, because in the plaintiff he has mentioned it.
In the plate, they have mentioned, my lord.
Yes.
Judgment was
So
against
for
me.
them, it is not a new thing.
Yes, my lord.
From the very beginning, they have implemented the state as party.
But my lord, my contention is that, my lord, when they have preferred this second appeal, my lord, whether that grant was taken in the memo of appeal or not, my lord, or my lord, that matter was agitated before this honorable court or not, when the matter was admitted, my lord. That is my point, my lord.
No, it may not be in the memo of appeal,
my lord.
But at this says they raised it, and there appears to be a substance in the same.
My lord.
So
When
let
my
there be a
learned
substantial
senior
question.
penny says, my lord, I have not any objection, my lord.
Let it framed, he can argue, my lord, that it is not involved. Let it be framed today. Framing is not allowing my prayer.
My lord. I will learn something, my lord.
Heard. Mr. D. Mazumdar, learned senior counsel assisted by Mr. D. Mazumdar, learned counsel for the appellant and Mr. T. Punya, learned counsel for the respondent. During the course of argument, Mr. Majumdar, learned senior counsel for the appellant, has taken this court to the plight and the relief claim in the plain, and also the judgment of the trial court, as well as the first appellate court, and also the memo of appeal. And he pointed out that though the state respondents arrayed in the plain before the trial court had not been arrayed in the memo of appeal filed before the learned first appellate court by the respondent, by the private respondent, and as such, there is a requirement of framing of an additional substantial question of law to the effect that whether the appeal could not have been maintained before the learned first appellate court on account of non-joinder of necessary parties. But having heard the submission of Mr. Majumdar, learned counsel for the appellant, this court has carefully gone through the plaint and the prayers made therein, and also the judgment of the trial court and the relief granted therein, and also the memo of appeal filed before the learned first appellate court. And it appears that the state respondents have not been arraigned in the memo of appeal filed before the learned first appellate court. In view of the contention being raised, and also in view of the issue involved and the relief sought for and granted, this court is of the view that the state respondents are necessary party. No, were necessary party in the appeal before the learned trial court, no, the first appellate court, but they have not been arraigned as respondent. In that view of the matter, this court is inclined to frame an additional substantial question of law as under as to whether the memo of appeal could not have been maintained before the learned first appellate court for non-joinder of necessary parties. Any other?
Lordship, in the preceding paragraph, your Lordship has mentioned that it appears that the state is a necessary party. That may not be there because that will amount to taking the decision itself. Lordship will hear and then subsequently decide. Lordship will simply say that it is framed, as suggested.
My lord, may I pay for a small observation in the order, my lord? My lord, during the pendency of this appeal, some new construction has been made. My lord, if my learned friend will instruct his client, my lord, my junior friend, my lord, to not to carry out any sort of construction till the next date of hearing, my lord.
Let there be an application. We do not know, my lord. In fact, my lord, I am told even this morning that suit was, my lord, both the parties have not very seriously fought the matter. Suit is for declaration of title and recovery of possession. This morning, my learned friend has been informed that the defendant is not in possession for last 12-13 years. So in that view of the matter, the recovery of possession relief is not necessary. So at the ground, it is very different. Lordship will not pass any observation at this stage. Let the matter be heard.
A small observation, but not to carry out further construction.
That will amount to giving an injunction without any application.
No, I am not seeking for any injunction, my lord. For preserving the suit property only, my lord.
Let them file.
No observation is necessary. You instruct both the parties not to carry out any such construction.
15 years have passed. What is the position? We also don't know. If he wants any observation, let him file an application so that the appellant gets an opportunity to confront those. Abruptly, if any observation is based on those paragraphs, these photographs were taken when, we don't know. What was the position for last 10, 15 years, we don't know. Let him file a formal application, my lord, lordship will consider. It's better, my lord.
You file it.
So that.
List the matter for final consideration on,
June, sometime in June, my lord.
okay.
Yes, all right. Obliged.
Right now, 29.
May I please, your lordship? Lordship, I could not prepare the brief properly, lordship. I need some time, lordship.
Lordship, I have a strong objection. Lordship, whenever this matter is listed, either they have a reason for suppose taking adjournment, or my lord today is saying that he is not prepared. Lordship, this date has been fixed as per his own convenience. Lordship, I ask this and kindly see the last order.
Lordship,
The date is fixed as per his own convenience. Just on last occasion, I have said that whatever date suits you, accordingly take it out.
lordship, I was supposed to argue the matter today, but due to some physical
Then Lordship,
problem,
take the
lordship.
interim order, no problem. Let them take time.
Pardon?
Let the interim order be vacated and take their time, no problem. My lord, I am fighting for this my right since 2011, my lord.
It's a defamation suit, this was a defamation suit, Your Honor, and this, the appeal is of the year 2023. And as some other old pending matters are there, which are at the stage of hearing before this honorable court. So I could not prepare this brief thoroughly, lordship. As because I had stressed in the old pending matters, lordship.
Madam,
Kindly
this case is not applicable, lordship, kindly see, my lord, on last occasion, lordship, he has found certain medical reason, then I requested him that take the date at your convenience. Now, lordship, today, what he is saying that he could not prepare the brief, lordship, it is not a good ground, better you leave it.
No. Yeah, that kind of,
No, lordship, thing is that, my lord,
No.
kindly see, my lord, because there is an interim order, it
No,
doesn't mean, my lord,
maybe-
you can delay the matter, my lord, it's a matter of prejudice to my part, my lord.
I am not delaying, lordship, as I beg to submit that the learned counsel for the respondent submit a wrong legal statement, lordship. That's why this matter was sent to the district and honorable district and session judge, lordship. Thereafter, that was again brought to the honorable court, high court, lordship. I am not doing delay. The delay is done as because of the
okay. Let us fix a very short date.
kindly in the month of June, lordship. As because in the month of the various matter are fixed, RSA are fixed in this honorable court, lordship.
Lordship, my prayer may kindly be considered, lordship, think that, lordship, there is no need problem for taking that. Question that, lordship, there must be justification for taking that, my lord. Now, 2-3 occasions, my lord, the date has already, and even it has not been informed morning, my lord, that he wants to take the date, my lord. Now, at this moment, he said he could not prepare the date. It is not a good ground, my lord.
And that's all right.
I-
You
I
could have
tried a lot-
mentioned the matter in the morning.
Lordship, I tried a lot till I was studying since morning 5 AM, lordship. Even though I could not prepare properly, lordship. Lordship, I beg apology,
I
lordship.
pray that interim order, because I don't feel that they are interested
Art.
in this matter.
Heard Mr. Sarma, learned counsel for the appellant, and Mr. Samaria for the respondent. Mr. Sarma submits that due to his preoccupation with some other matters, he could not prepare the brief of this case, and as such, he prays for little accommodation in this matter. Though Mr. Samaria, learned counsel for the respondent, has opposed the pair, yet taking note of the facts and circumstances on this of the case, and also the submission of Mr. Sarma, his pair stands allowed, list the matter on.
My lord, last chance, lordship, that observation.
It is
100 chance.
being clarified that no further adjournment will be granted to Mr. Sarma.
Second May, second.
Second May.
Second May.
Second,
Kindly in the first week of June, lordship. I will definitely argue the matter on that day, lordship.
second is not possible.
Kindly first week of
First
June,
week of
4th June.
On No, on 14th,
June.
May, not June.
on 14th May.
May.
14th May.
Yes, yes. Thursday is better.
First. Adjournment.
Highly obliged, Lordship.
May it please your lordship. Happy civil revision petition, your lordship, against the order dated 2/7/2025, passed by the learned civil judge Chirang Kavilga, entitled suit number 13 of 2021.
What is the impugned order?
It is there in page number 57, your lordship. And effective order is is in last page 70. Okay. 76 and 77. In the last paragraph of 76, I would like to read, your lordship.
77.
Yes, page number 76.
Yes.
Last, the question regarding the suit being barred by any law is not reflected from the perusal of the plain. The question regarding the non-maintainability and bar of law has only been raised by the defendant side after submission of their written statement. As such, the condition for rejection of plain as mentioned earlier is not fulfilled in the present circumstances. Hence, considering the above, the prerequisite for rejection of plain under order 7, rule 11 of CPC stands rejected. This is one of the ground, the plain reading of order 7, rule 11. But what I pointed out, your lordship, the crux of the matter is, your lordship, at page number 30 of the plaint, which they have which the plaintiff had filed. Page number 30, appropriate portion. Page number 30, para 9, your lordship. We had raised the objection that is barred by law because it's a tribal belt and block coming under chapter 10 of the Assam Land and Revenue Regulation, your lordship. And there is an appropriate forum concerning
Page number 20.
Page number 30, your lordship.
30.
So a plain reading was not in total when we look at paragraph 9. In paragraph 9, in the plaint, it is stated that the cause of action for the suit arose in 39/2016 when the defendant number 1B and 1C submitted a petition before the Circle Officer, Sidley Revenue Circle, on 21/8/2019. When the Circle Officer, Sidley Revenue Circle, Sidley cancelled the mutation of the plaintiff and other recorded co-partners from the revenue records of the suit land. And on 31/1/2020, when the defendants number 1B and 1C started some measurement of suit and tried to dispossess the plaintiff from the suit land, all concerning suit land in village Bilaspur and within the jurisdiction of this honorable court. So this Revenue Circle, Sidley Revenue Circle, or order 21/8/2019 is this one, your lordship. At page number 35, your lordship. This is the original actually cause of action. In this the circle officer can come into this in this type of nature, can decide in this type of nature of the case only when it comes within the purview of chapter 10 of the Assam Land and Revenue Regulation. Otherwise, the circle officer or the executive officers have no right. Directly, the matter has to be fought in the civil court, your lordship. Here, the matter came, both the parties were present. They had entered into the domain and the jurisdiction of the chapter 10 already. It was heard, it was decided properly. And in the plaint, it was mentioned, concerning this order. Now, annexer, your lordship, is an integral part of the plaint. When we say in our order 7, rule 11, that a plain reading of the plaint, it shows
it doesn't show that there is, it shows or it doesn't show that it is to be barred by law. But here in this case, it comes within the purview of Sidley Tribal Belt and Block, Your Lordship. The same patta in 35 second paragraph. In course of the trial of the case, it is seen from the land records of page number 35, Chita copy and Jamavandi of land in dark number 193 and 197, patta number 17. There's a land.
Where is your application? Where is your application?
The application, I did not directly, I submitted the this order. Written objection.
No.
This was a prior.
Fair was for rejection of plain.
Yes, no, prior to the suit, this was already contested before the revenue officer. That means it comes within the purview of chapter 10 of Assam Land and Revenue Regulations. What happened, the plaintiff?
No, you have prayed for rejection of plain.
Yes. And
where is that application?
Yes. I did not. I have submitted a written statement, Your Lordship, but objection petition, I think I did not annex here, Your Lordship, I think so.
Objection petition means?
Along with the written statement, along with the objection of objection against the maintainability of the suit. Here I have submitted my written statement. I have annexed it here. I could not annex the copy of the that written objection separately, which
Copy is with you?
No, copy is not with me, Your Lordship.
Copy is there with me, my lord.
With you?
Copy, whatever the application filed by them under order 7 rule 11, that is there with me. And as against which I had filed my objection, based upon which this order was passed. So that copy, if your lordship desires to see, I can.
Okay, can
Order 7 rule 11. No, it is. Written objection into.
I couldn't annex the written objection file, so I apologize.
It will have a written objection. Written objection as a petition, as a official. Objection as a petition too.
I must have missed it while drafting the petition, Your Lordship, but contentions are clear. Because the affidavit has not been filed by the other side, Your Lordship, here in this case. They can produce it through a.
No, there is no requirement. They may file it, may not file it.
It was my objection.
Or let me be allowed some time to file that as an additional affidavit, Your Lordship. I beg before you, Your Lordship, for the ends of justice. Otherwise, it will be short of my arguments. Give me some time, Your Lordship, so that I can file an additional affidavit.
written objection বেলেগ কে দিব।
This is your objection,
Which one?
this one.
My lord, that the other one is their application, which I have just now given. The reason application, my lord, contained that application, reason being that while appreciating the, the application as well as the objection, the learned trial court has already gone through the various paragraphs and has written from page number 68 downwards about what is the petition made by them, what is my objection towards that. So he ought to have made that application an annexure of this.
I missed out, Your Lordship, for let me be allowed to file the additional affidavit, Your Lordship, because for a long time it is, this matter has not been listed.
Okay, Mr. Sattar,
Yes, my lord.
let him bring on these documents on.
Yes, I'll allow.
By filing.
No objection, my lord.
But the only problem, Your Lordship, in the trial court now, the matter is just was a step before the preliminary hearing, Your Lordship.
Let them go on.
So
Let them continue. Let them continue with
there
the.
was my prayer also for interim for a short time till this one.
No. We'll finally hear and dispose of the matter.
Yes, my lord. Let it be parted, my lord. My lord, I will request that let it be parted.
Not required.
Yeah,
Will come because I'll.
It would have been totally heard today if you would have filed that application under after 7/11 before your lordship. Finally, it would have been heard.
Your Lordship has seen that there is an
Okay.
this a
Heard,
record. in
Mr.
hand.
Nazari, learned counsel for the petitioner, and Mr. Sattar for the respondent. After hearing Mr. Nazari, learned counsel for the petitioner, this court finds that the application filed by the petitioner hearing under order 6, the order 7, rule 11 of the Code of Civil Procedure read with section 151 CPC, and also the objection filed by the respondent hearing has not been enclosed with the petition. Mr. Nazari submits that he may be granted some time to bring on record the said petition and the objection by filing an additional affidavit where allowed, list the matter on.
Yes, Your Lordship. 2nd week of June, Your Lordship. Because I will take time for me.
As parted.
Then let it be on 17 June, Your Lordship. Let it be on the hearing, next hearing date. Oblige, Your Lordship.
May
Yes.
My lord, I have challenged the impugn order that is passed by the additional district judge, my lord, in miscellaneous appeal. Background of the case, my lord, the petitioners, my lord, has plaintiff, my lord, filed TS. Settled suit number 3 of 2024. Praying for my lord is a declaration of right title, interest and confirmation of possession. My lord,
Madam, before saying anything by my friend, madam, already in view of the court's order, madam, this passed by the assistant decision, madam. Already trial has been started, madam. Only this when the injunction was issued, madam, injunction order was passed. Then from whom I purchased the land, he was not made party. The land was just I'm giving one line this man. The land was purchased from his father in 1981 by way of registered sale deed. And that's the from B,
who purchased the land in 1981. I purchased from him my land in 1991. And he has filed the title suit in 2024. And he has not made the party to to that person who purchased the land in 1981, registered by way of selling. Now only party has been made against me. But so far, I purchased the land from me, not from him.
No, now what is your contention?
Now, my lord, the injunction was issued. In my absence, my lord, the ex parte injunction was issued. And when I was continuing my possession, my lord, up to 2024, and there is a circle officer report, my lord, that part, when I continued and I paid and my name was mutated as patta holder, in 2024, he has filed a title suit. And meanwhile, there was a execution case, my lord. In execution case, circle officer's report was called for. Then circle officer has said that since the possession, this respondent number was in possession as per the record. And in the meantime, this setting aside all this execution proceeding, he has filed title suit. And by suppressing that, and thereafter he obtained the injunction. And by virtue of the injunction, he has taken my possession, my lord, on the basis of this execution, my lord. This injunction. And it
No,
was-
no, Mr. Secretary, you will get a chance. First, let him argue. He has
was
the right
case.
to begin.
Yes, yes, that was the case, my lord.
Yes.
My learned friend submitted that after obtaining,
Submit, my lord.
after obtaining injunction, I enter into the possession. My prayer, my lord, already there for confirmation of possession in the suit, my lord. And the prayer portion is
Where is the plaint?
plain, my lord. Yes, plaint is, my lord, page 18 and prayer portion page 24. Page 24. Prayer, my lord, first prayer, the suit be decree in favor of the plaintiff. Second prayer, the declaratory degree pass be in favor of the plaintiff by declaring the plaintiff have right, title, and interest. And my lord, sixth prayer, the confirmation of
Confirmation of possession.
Yes. So, my lord, my humble
You are-
submission, what is about submitting, my lord, by my learned friend, that after obtaining injunction, I pray for, I enter into the possession, it is not correct position. Anyway, my lord, I, along with the plain, my lord, I filed the miscellaneous J 3 of 2024. And my lord, it was ex parte order, no doubt, my lord. Page 36, page 37 is the order dated 4/1/2024. Is the first injunction order, my lord. If you lordship see the operative person, which is at page, my lord, 44.
40?
44, the operative person. Accordingly, aid interim injunction is granted and thereby the opposite parties are hereby restrained not to cause any disturbance to the petitioner and not to enter the suit land by opposite party, his laborers, other family members, agents until further order. This is no doubt, my lord, ex parte order. My lord, thereafter, order was passed after hearing both the side. After getting, my lord, objection from the other side, my lord, which is page, my lord, 76. Page 76. The order dated 1/10/2024. This was, my lord, passed by hearing both sides, my lord. And operative person, my lord, kindly see. page 82. So for the principle of balance of convenience, I'm reading my lord page 82, second paragraph. So for the principle of balance of convenience is concerned, it shows that the same also lie in favor of the petitioner. That is myself, my lord. It is also seen that if the prayer of the petitioner is not granted, it will cause irreparable loss and injury to the petitioner, and moreover, it is not possible for the present court to appreciate all the document and evidences furnished to the both sides of this initial stage, and contrary, if the prayer of the petitioner is allowed, it will no way cause prejudice to the opposite party, because they can always compensate it in terms of money if they succeed in providing their case. Keeping in view of the above discussion, the injunction is preferred for is hereby granted, and opposite party and his fellow are hereby restrained from entering into suit land till disposal of the main suit. So, my lord, this order was passed by after hearing, after filing objection. It was passed. My lord, in the sole opposite party, my lord, sole opposite party, my lord, filed, my lord, WS along with my lord counterclaim. Counterclaim, my lord. There is page 45 is the WS, their WS and counterclaim. Counterclaim, my lord. Prayer in the counterclaim is page 58, my lord. That the suit of the plaintiff be dismissed with cost, that the counterclaim be decreed with cost. Prayer number 3, that the right title interest of the defendant be declared over the suit land. 4, that the decree be passed for evicting of the plaintiff from the suit land possession of the defendant be restored. So recovery of possession is there, their prayer is there. My lord, it is strange that, my lord, with counterclaim, the sole respondent not file, my lord, injunction petition. Not file. So, my lord, the appeal kindly see the impugn order, page 101. 101. My lord, this is the appellate order. My humble submission, my lord, appellate court might have rejected my prayer of injunction. But what sort of order passed by the learned appellate court? Kindly see, my lord. Page 131, my lord. In view of the paragraph 36, in view of the above discussion, the mis-appeal is allowed, setting aside the order of the injunction dated 4/1/2024 and 1/10/2024 on finding illegality and perversity in discussing the golden principle of injunction and passing the order without perusing the pleading of both the parties and document on record. Accordingly, possession which was in favor of the appellant, defendant, opposite party, it be restored till disposal of the main title suit, case number 3 of 24. OC, Udalguri PS, shall do the needful for lawful restoration of the suit land to the appellant in accordance with law. Kindly see, my lord, this kind of order without petition, appellate court pass, my lord. Restoration of possession, and OC was directed to deliver possession without, my lord, petition, without, my lord, injunction petition. My injunction petition might be dismissed or not allowed. It is different thing. But second part, my lord, how my petition can be delivered in injunction petition without any injunction petition, without any petition of any kind. The restoration of possession and OC was directed. That is why, my lord, I have here, my lord, This is absolutely without jurisdiction, without any petition, without any prayer. This type of order was passed by appellate court, which is, my lord, not tenable under law. This is my sum and substance of the argument, my lord. This is my case. My lord, the learned appellate court finished the case. My person,
Where
yes.
is the memo of appeal filed before the appellate court?
The memo of appeal, my lord, I have not in it. My lord. Memo will not need, my lord. Oh, sorry, my lord, it is there. It's page 83. Page 83, my lord.
Page number?
83. In the memo appeal, my lord, prayer is there, page 90. Therefore, pray that your honor may be pleased to issue notice to the respondent to show cause as to why the order dated 4/1 and 1/10 passed in Miss J case number 3 of 24, a raising of title suit number 3 of 24 by the learned civil judge, senior division, Udalguri should not be set aside. And quas, and please pass order for restoration of appellant's ownership, right, title, and possession. So, my lord, this is second part of the prayer for restoration of the appellant ownership, right, title. These are, my lord, subject matter of trial. In my lord, injunction petition, this type of prayer was in the appellate stage, my lord, made. In appellate stage, my lord, sole respondent can pray that it is illegal order passed by the trial court, granting injunction. But how can pray that restoration
So,
of the possession?
Prayer is there in the memo of appeal.
Yes.
But according to your power is not there.
My lord, in appellate stage, this was the challenge of the, my lord, injunction order. Yes. Challenge of injunction order. And right title interest, my lord, it is the subject matter of the suit, not the injunction petition.
Mr. Satre, no, sorry, Sohan.
My lord.
Here, page number 99 of this memo of appeal is not available.
Page number 99 in what?
98, after 98, directly 100. So the other part of the pair I could not go through.
Oh, my lord. My lord, some mistake is there, perhaps, my lord. Perhaps there. My lord, certified copy I have, my lord.
You have.
Yes, it is different.
There was something. What kind of copy it? So, Mrs. Satre, whether the appellate court has power to restore the possession at that point of time?
No.
Because trial was not started.
No, my lord, since here up to 2024, I was in the position, my lord. Up to 2024, till passing of the injunction order.
No, we are not concerned with that. We are concerned with whether the court has the power while examining the legality, property of the impugned order of granting injunction. Can trial court pass such kind of order restoring possession?
My lord, since this order has been set aside, this injunction has been set aside by the this appellate court,
Hmm.
considering all these golden principles of this injunction, my lord. And my lord, since all these provisions have not been followed at the time of passing the injunction.
No, that's all right.
That's true.
As submitted by him, he has no objection in setting aside the injunction order.
Lordship.
But he has the objection in passing such kind of direction.
Restoration, my lord, since till 2024, I was there. Probably I have to check, my lord, because
No, you see, by restoring the position, the suit appears to be determined by the court. Fate of the suit has already been determined,
my lord, this is.
but the trial is yet to start.
My lord, no, trial was already been started, my lord. My lord, only my understanding, my lord. I may be wrong, but since the possession of the land was till 2024, my lord, till passing of the order, injunction order. After passing of the injunction order, now they have taken over the possession of my land, my lord. And immediately with the 13, 15 people went there and they took the possession forcefully, my lord, by taking police, all this, my lord. Very second day. Then, my lord, we have when we have approached before this honorable court, then we have filed this objection, all these things, my lord, but it was not considered. And subsequently, my lord, when we have filed an appeal, my lord, before this honorable court against the injunction, my lord, then certainly once the land was in my possession, the question of restoration of my possession will come, my lord.
No, then why the trial is necessary?
No, my lord, this is not decided as a whole, my lord. This is decided only for the on the basis of the interim injunction, my lord. Then let the trial be decided. Let trial be decided on merit, my lord. What is what, my lord? My lord, only here, even if we go to the merit of the case, otherwise also there is the limitation, my lord. The bar by
No,
limitation. All these
those
things are there.
those are the subject matter of trial.
Trial, my lord.
But at this stage, his grievance is only that. Okay. His injunction order is set aside, set aside. But this restoration of position, these orders, whether the trial court, no, sorry, appellate court has the power to restore the position.
That part I have to check, my lord. That part I have to check. When
So,
lordship is
okay, then you come prepared on Saturday, day after tomorrow.
Saturday, my lord, some other day lordship. Not Saturday, some other day lordship.
Why?
Saturday I have some other works, my lord. At home, my lord. Some other day lordship will fix. I have to take lordship rightly said here. Then whatever the points is there, I have to check it. I will check it.
Third, Mr. Sohan, learned counsel for the petitioner, Mr. Setri for the respondent. Heard in part, list the matter.
Yes.
11 June.
That part I will check.
My lord, substantially lordship heard, my lord. That is why, my lord, if my lord is kept part heard, my
Yes, perfect.
That is that.
Perfect.
Was it?
Alright. इसको याद है पीना था मैं छोड़ दो कैसे फिर इस नासे ले यार जरा उसको याद नहीं लगा कुछ
Only that, my lord, probably, so I understand restoration part.
yes
Wait, please, your lordship. Lordship matter may be pass over for the day.
why
Lordship, my senior had to leave the court urgently.
who is your senior
Miss R. Chaudhary.
miss your name please
S. Ahmed.
S. Ahmed, learned counsel appearing on behalf of Miss
Miss R. Chaudhary.
R. Chaudhary, learned conducting counsel for the appellant, submits that her the conducting counsel, Ms. Arsuduri, left the court. And as such, he pressed for adjournment of the matter for the day. Any objection? The learned counsel for the respondent submits that he has no objection. Here allowed, recessally the matter in the first week of June.
Authorized.